Happy Friday Night Live. I know that I sound awful. I feel similar to how I sound, but I've got some hot water and lemon, and we're going to talk about the pop culture legal stuff that's going on this week because it's been a stressful week. It's a stressful evening. I'm sure there are a lot of you that are in time zones that are normally asleep right now and aren't asleep. We're going to talk about that too after I roll the intro. Just a quick heads up of what's on the docket tonight. We're doing a roundup of everything. So I'm going to talk a little bit about Jeff Whitick and David Dobrik. I've seen a lot going on online about that. We're going to talk about Amanda Bynes filing to end her conservatorship. We're going to touch back in with some nonsense that's popping off in the Chalene Johnson case. Jen Shah's attorneys tried it. I think that's going to be a big negative ghostwriter. The pattern is full for them. There are tons of Maxwell updates, but we finally have Juror 50's questionnaire. We're going to talk about that. And the Kim Kardashian Kanye West divorce that months and months and months ago, I said, hey, they've got a prenup. This should be smooth sailing, has gone left. It's just like, just kidding. What we're not going to do is have a smooth sailing. And, one of the internet's other legal commentators, Christopher Melcher, who a lot of you enjoy and follow, I enjoy too, has done great coverage of the Britney Spears case, is representing Kanye West. So we get to see some of his filings as well. Always fun to see a name that we know. So with that, if I have to pause to blow the schnoz, I will let you know because we're not doing that on camera. It's just going to be. But what we're going to do is just get through all of the cases, and yeah, we're going to do the things. But I will touch on what's going on in kind of world politics in after we roll the intro, because we're going to. This is a political free zone. We are a respite here to talk about pop culture, but we acknowledge what's going on in the world in the way that works best for me, which is I'm going to let you know how I parse so much information coming in and all the feelings and some of the places where I find help to donate and what have you. So that's how we're going to address that, what we're going to address. Replay crew, love you. I will be timestamping tonight after we are done, doing my best to make sure I have them. I will try to remember, but I figured tonight we all just need a minute to talk about something else. And that is why it was really important for me to go live tonight so that we can just talk about something else and come together. And in the chat, I really don't mind you guys chatting. We are here to support one another through the shit that's stressful. And that's what we are here for. So let us move into the intro. We are going to do court of public opinion at the end this evening. Like, raise a glass of whatever you got, and we're going to go through it all together. We're in it together tonight. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. We've got lots and lots and lots going on tonight. So we are just going to get started and get into it. I'm not even going to run the weekly roundup because we've got so much to round up. But what I will say is there is a lot going on with Russia invading Ukraine. I talked about this a little on Tuesday before I realized how much everything was going to pop off. I understand briefly American politics. I really focused my studies on law and the Constitution. I am a lawyer. I am not a geopolitical expert. I am not an international relations specialist. I do not know the things. I follow, and I shared this in my Instagram stories, the news sources that I follow, things like Her News or Smart Her News and the Newsworthy podcast, which is like 10 minutes of news. They both do interviews with people who are experts. I don't do those kind of interviews. I love following Allison Morrow here on YouTube for interviews, and she's also on Rumble because sometimes her YouTube content where she does interviews asking people questions, YouTube gets salty with. I look for news sources that don't try to play to my emotions and spin that up because that doesn't work well for me. I want to know what is happening. I don't want to feel emotionally manipulated by the news cycle. I don't like things that are catastrophized. It does not work for me. So I look for news cycle that is like, this is what is happening. And then I look for ways that either I can help or when I need to step away. I love what Bethany Frankel's Be Strong organization does. I will put a link in the description box after the live. I find that her humanitarian aid is one of the fastest acting organizations I've seen. I have never seen a complaint about what they do on the ground. They operate very, very quickly. They use a lot of donations to cover overhead, and she has the celebrity to do that. And she uses it to call in favors and get as much aid on the ground as she can. So, when feeling like we don't have control and things are overwhelming, sometimes it helps just to look to an organization that's helping and watch how they're helping. That is what I find helps me. I want to see the facts of what's going on, and I want to see how people are trying to aid the humanitarian side of it. Because again, when countries um, go to war, it is people who bear the cost. And that is a cost that I think weighs heavy on all of us. One of the things that I strongly believe is that people should be safe. Like it's a basic fundamental human right to be safe. And that is not what's happening right now. And I know, and I've seen a lot of people in Russia commenting that this is not what they want either. And it has to be very frustrating watching your country do something you don't support. So, with that, those are the places that I go to try to find what is happening so that I stay informed, but without feeling like I'm being dragged into the doom scrolling rabbit hole of a mental health spiral into it is the end of the world, because that doesn't help anyone. So I have friends that are Ukrainian. It is just, again, it's heartbreaking, and it is going to be a long night. And for all of you in uh, Europe, it's going to be, this is going to be long, and we love you and we are thinking of you. And whatever we can do to support and help and share, we are here. And that's why I share Be Strong, because it is a humanitarian effort, and it is taking care of the people who are displaced when countries um, go to war with one another. So, with that, it's not that I am, I mean, there's no other commentary I can really give because I don't have that expertise. So, what I can give is a space for all of us to get together and say, hey, this is what's happening. It is awful. Here are some resources. And for a little bit, we are going to talk about pop culture, talk about other things, and look at the lives of celebrities who are getting divorced and just be like, okay, let's just focus on something else. And that is something that we can do for a little bit to give ourselves a mental respite. And that is really what I'm here for, is so that we can break down the law and pop culture on other things, especially when the world is heavy, which is why, even though I haven't covered a lot of what's going on with the Kardashian West case, I wanted to balance that out tonight. We're going to talk about some Jen Shah nonsense. And that's why we're touching back in with David Dobrik and Jeff Whitick, because again, it's just, where can we talk about the little things? And this is where we can talk about some of the little things. So I should have pulled up what I was looking for. We're gonna play some audio clips because we're just gonna give a little commentary on what's going on with David Dobrik and Jeff Whitick first. That's what we're doing. But I need to pull up Instagram because I'm gonna take clips from Def Noodle's Instagram because he always clips them, he shares them, and they are concise, and then I don't have to pull through 3 hours of the H3 podcast talking about this. I can just pull up Instagram and do it that way, and try to get Dennis without hiccups in this. So that's what we're gonna do first. I should swoop the things. I appreciate all of you. I appreciate you for being here. This is a safe space to just be, and some of us need to just be tonight. I am with all of you on that. So let us go on. Let us just, I can't even sing tonight. Like, this is where we would just bust into like, my heart will go on and on, but There's no way. There's no way. Oh, I should tell you what's coming up in the podcast next week, and the video will be live a little bit early on YouTube. Um, we're going to be talking about the Brad Pitt, Angelina Jolie winery in France lawsuit that's kind of tangentially related to their divorce, but not. It's wild. I tried out something new for our YouTube members, Patreon members. This is coming for you next time. I tried out something new on a whim, the way that your ADHD girl does. It's like, oh, I have an idea. Oh, execute it immediately. Do this now. Literally, thought popped into my head. Do this now. And I recorded that live with the members, and then I'm gonna go edit it down. So that video will be up. It was a lot of fun to do, and I think that I will be adding more behind the scenes recording of my podcast for the members and the Patreons if you want to jump into a members only stream and just watch me do the behind the scenes of how I record the podcast and see those stories first before they get cleaned up. You get to see the bloopers in real time. You get to see me go, we're gonna try that one more time because that sentence came out all fucked up. So that will be up tomorrow, and it is a very, again, if you need a distraction, talking about a lawsuit over wine with like deep next level rich people business organizations, that will be up for you. It is a very interesting lawsuit, and I'm very interested to see where it goes. So with that, oh, Sister Babylon, thank you. Happy Friday. I just joined Patreon at the 3 level. I finally figured out how to use my boy name, but whatever. You can use whatever name you want. I'm sorry if they made you use a different name. We can always go in and change it. I can help. Just DM me on Patreon and I can help you change that if I can. And thank you. I'm so excited. Yay. So with that, let me pull this up. And there's been a lot of clips on this. So I want to make sure I pull up the right one. So if you guys don't follow Dennis on Instagram and would like to, you will see that here as I share the screen, and we will get to the audio. I hope. Let's see. Let's make sure it's turned on. Yes, it is. Audio input is helpful. And we're going to, I don't really care what Trisha Paytas has to say. We're going to go to this because what I've seen on the internet is a lot of conversation about whether Jeff Whitick can sue David Dobrik. And that's, for our purposes, what we're going to talk about. Oh, I should have swooped. Emily, swoop. Swoop. And I need to change where my audio output goes so that this doesn't echo for you all. See, we're professionals here, especially when we are under the weather. I've seen a lot of questions about whether Jeff Whitick can sue David Dobrik. I will give a background of actually, let's do that first. For those of you that don't follow this particular segment of the internet, I totally get it. I had no idea who David Dobrik was for the longest time. That is like quick cut YouTube is not for me. I lived in 18th century dress clothes for 5 years from Abby Cox. That is my space on the internet. That is where I live. If you want to know the kind of things I live, like Sophia blending every like candle from wherever together, that is where I'm at. The Vlog Squad, I'm too old. The quick cuts is not for me. It's just not. When I first got my Tesla, one of the neighbors, their daughter came out and was like, "Oh my God, it's just like David Dobrik's." And I'm like, ooh. So my awareness of the Vlog Squad and David Dobrik came up through drama. That's where it came up from, and seeing really the H3 podcast and Trisha Paytas talk about that drama. But during COVID, for those of you that don't know the story, David, and I have a video covering this, talking about whether there could be a lawsuit ages ago. When David Dobrik was making like a return from COVID video with the Vlog Squad, they went up to Utah and they got this giant freaking excavator. And Jeff Whitick did a whole summary on his channel of what happened. If you guys want to go watch it, go watch it. There are parts that are graphic and injury, and it's just, it's a lot. But at one point, Dobrik decides to swing the excavator around with a rope attached to it of some sort, and Jeff Whitick on the rope. David has a camera in one hand and the excavator in one hand. And it seemed like at the time Jeff Whitick was being blackmailed. That's what he shared over releasing what happened in the incident. So he decided to make a series out of it and release it. He has now had his 9th eye surgery. The side of his face was collapsed in. It is a horrifying video to watch. The extent of his injuries were fairly substantial. The fact that he survived this accident is to me kind of shocking. When you see the incident, you're like, oh my God, I thank God he survived this. But with that, there were never criminal charges that came out of that. Do I think there could have been? Yes. Do I think this was negligent operating of a excavator? Seems to be, but there wasn't. I don't know if police were ever involved. I don't know if they ever called an ambulance. I don't know those things to answer those questions more. What I do know is Utah generally isn't super tolerant legally to fuckery. Utah is like, no, what we're not going to do is that. So the fact that Whitick has gone through so many surgeries and it continues to have life-altering injuries is one of the things that when you look at a plaintiff's lawsuit, you're like, yes, you have life-changing injuries, not even just over the last year and a half or whatever since this happened, but potentially for the rest of his life. Each time he has surgery, there's a chance that he will lose his eye or go blind. It has changed the shape and look of his face. And while that isn't something everyone cares about, it is something that can be compensated for, because but for David Dobrik spinning this excavator around, and stories are now alleging that he told Jeff, let's do one more take, we'll just go slow, and then spun it so fast. Some have speculated that the excavator's internal mechanism is what stopped it so fast, because it was spinning quickly with like the centrifuge rope going out, and then the excavator came to a dead stop and would it continue to spin and hit the side of it. So with all of that, people are going, could Jeff Whitick still sue? Yes. Jeff, a plaintiff's lawyer, will help you. Los Angeles is full of them. There are lots. Find one. If you need help finding one, reach out to someone who has a lawyer, like maybe H3. Maybe just don't insult him and reach out to him. DM me. I know lawyers, but yes, he can still sue if he chooses to. Plaintiffs' lawsuits are long. There will be discussions of contributory negligence, like while he got up on the rope, so then what? It's not fun to go through. But when you are injured in that way and you are going to have to continue to have medical need, it is appropriate to seek a lawsuit for those damages, and can seek a lawsuit for those damages. So the statute of limitations, the questions I've seen are, has the statute of limitations passed? No. Generally, there's a 3-year statute of limitations on this, because Jeff Whitick knew of the injury at the time it happened. It's not like he found this out later. With that, Jeff Whitick knew. So generally a 3-year statute of limitations. They both live in LA, so he could choose whether he wants to sue in LA or sue in Utah where the incident happened. And it seems that something has broken down in the relationship, and the relationship might have kept Whitick from suing. Lots of plaintiffs are like, look, my friend was driving, we got in a car accident. I don't want to prosecute. I don't want to sue. I don't want to do any of this. That's my friend. It seems that something in the relationship has changed, because Jeff Whitick has been going off on social media about this, and that's what we're going to talk about right now. So yes, this is a little more of the drama tea side of YouTube than we talk about, but the question being, can Whitick sue, is a very good legal question. And I hope that there are law professors out there going, this is a perfect example for a torts class. So let me try to get the volume on here. All right, let me turn the volume. I can't turn the, oh, we'll just have to do this.
8 years old and go through another eye surgery and have him fucking text me.
I'm going to turn this up just a little bit. You guys let me know if you can hear. Instagram makes it hard.
I could be 80 years old and go through another eye surgery and have him fucking text me. Yeah, I get that. The real reason I was mad, it's going to come out publicly in a month anyway, but David filmed a documentary, and the producer of the documentary, creator of the documentary, director, whatever you want to call it, he called me, FaceTimed me to show me the clip of the interview when David addressed the situation with the crane. And he said that it was my fault. David blamed me for the crane. He insinuated that I was crazy. I always want to push it. And I'm the reason that this happened. When that's complete bullshit. There's 20 people on the beach that are witnesses. I have fucking 6 terabytes of footage of you asking me, begging me to go out there and do the thing again, and that you would spin it slow. You just want to take me out there because it's more scenic and it looks better on camera. It's more cinematic. And just to hear him sit there and say that, I was like in shock at first because I'm looking at it over FaceTime and I just couldn't believe that
He
he
should
would
be
say that.
pissed.
Year I could be 80 years old and go through another eye surgery and have him fucking text me. Yeah, I get that. The real reason I was mad,
that
it's going to come
restarted.
out publicly. Does he not really give a fuck? But imagine you smash somebody's skull in, they take it on the chin, they don't sue you, they don't fucking press charges.
He can still sue. Jeff still has that option. He can still change his mind. The fact that he hasn't sued yet doesn't bar him from suing. He is going to have lifelong medical need. This might also change what he is able to do, the brand partnerships that he gets. He has had damages, actual damages that he can sue for, and needs to talk to a lawyer and preserve all of that video. Because there's video. David's holding a camera, Dobrik's holding a camera in one hand and spinning the excavator. You need to make sure those things get preserved. And having a lawyer can start making sure that you preserve those. Because at this point, it seems that Jeff Whitick's already out of the vlog squad. The friendship's not going to be repaired. So you've got to do what's right for you, for your lifetime, and for your future medical needs, because you don't know how this will affect you in the future. I mean, if he has a surgery go wrong, he could lose his ability to drive and need to have someone drive him for the rest of his life. I'm sure his depth perception has changed based on the eye injury and the skull injury. He had a traumatic brain injury, which fundamentally changes the way, or can, I should say, fundamentally change the way you process information, think. It can lead to things like migraines, etc. So there's a lot of need there. I'm just surprised. I guess I'm not surprised that he didn't sue. I mean, that's, friends don't always want to go that route, and suing can be terrible, but he can.
I mean, anything could have. I would nearly died. I came an inch from death and an inch from going blind. I'll have lifelong brain injuries and save them from fucking
Should have
everything.
kept reading.
You would have got deported. You would have got put in jail for manslaughter. You could have got sued for everything. I took it on the chin, and then to see this, and that just made me completely lose all respect for this guy and lose all hope that he could ever turn around and become a better person. You know, I know he does a lot. He's supposed to cover the hospital dealing with it. I have Ivan, my assistant, deal with it, and he goes with David's team, and they didn't pay a fucking bill. I got an infraction on my credit now. I go to get a house and I can't get a loan because now
Right.
I have another. So it's just like things are piling up over and over again, and just try a little bit. For those who think I'm trolling or I'm fucking crazy on Instagram, honestly, I could give a fuck.
I don't think he's trolling. I don't think he's crazy. The medical bills are no joke. 9 surgeries is no joke. This was not his fault. So, you know, with all the commentary I've seen of, can he still sue? Yes. Yes, Jeff Whitick can still sue. Will he choose to is another conversation. He indicated in his series, and if you want to watch it, it's on Jeff Whitick's YouTube channel. He indicated on his series that they've never signed anything. Like, there weren't releases signed, there weren't he didn't pay for anything, and or David didn't pay for anything and have him sign a settlement agreement. So, based on the information available on the internet, it seems that he can still sue. So he would need to do that before the statute of limitations runs out. That statute is generally 3 years, but can be different depending on it. But now is the time to talk to an attorney. This was like a year and a half ago. Now is the time. Preserve everything that needs to be preserved. It could be a battle, but I also think that it might be one of those things that just settles. If he does sue, just settle, because, you know, I'm sure that David Dobrik has the money, and I'm sure that the lawyers can work out some kind of resolution, which is going on in the Bill Paxton wrongful death lawsuits right now. We haven't covered those on the channel, and maybe I will, but it looks like they've just reached like $1 million settlement. So this fundamentally changed Jeff Whitick's life. And though there are definitely things Jeff Whitick has done that I don't agree with and that are super douchey, no one deserves to be injured like this, essentially at work. He was working with the vlog squad and shouldn't shouldn't have been injured in this way, especially if he was induced to get on it by David Dobrik saying, "Hey, I'm going to go slow. This is what we're doing." And then David changed that as he's operating a giant excavator with the camera in his hand. So call a lawyer, Jeff. Call a lawyer. Call a lawyer. Call a lawyer. Most plaintiffs' lawyers would take this on contingency. Look, Attorney Tom probably has plaintiffs' lawyers in California, or can pro hoc vice in. Saltsy, I'm sure, has plaintiff's attorney as at his firm. The firm that H3 is working with, that's been doing a great job on his defamation, also probably has lawyers. So lawyers will take this type of case on contingency because it's going to get paid out. There's video. So with that, I think he probably should have done that at the beginning and was trying to be a friend. And a lot of people find themselves, um, harmed at the end of the day with that. So with that, we should move on. Let me swoop again. Let me swoop again and talk about Amanda Bynes briefly. Briefly. We're not getting into a whole deep dive tonight. I'm just giving you the heads up. But for those of you that aren't familiar, and I'm sure some of you are and some of you may not be, and that's fine. Amanda Bynes, from She's the Man, from like everything that was good in the 2000s, has been in a conservatorship for the past 9 years. This is also a California conservatorship. And let me see if I can bring this up without it completely crashing my computer with ads. I try to do the ad scraper, but it scrapes all of the images. So let's pull up people reporting on this. I will pull the documents if you guys want to do more of a deep dive into this conservatorship. I can do one with Amanda Bynes and Bam Margera's conservatorships together. But let's pull up people.com. Amanda Bynes files to end conservatorship. She believes her condition is improved, says lawyer. Well, it's interesting. The first thing I noticed is that, oh, I'm going to sneeze. Oh, we're going to sneeze. We're going to sneeze. We're going to sneeze. I'm just going to go to music now when I sneeze. What's interesting to me is that the lawyer has said she believes her condition is improved, which is very, very different than what Britney's lawyers were saying. So again, these are two very different conservatorships. The way that her lawyer has worded this is mm, interesting to me. That it is she believes. So with that, you guys are saying something sounds off with the microphone. Okay, let me take a check of that. Did the music screw up my mic? I hope not. I hope not. It should be okay. That might be a StreamYard thing. Hopefully that's better. Um, sorry y'all. There's an echo. That's weird. Let's see. Hopefully that's better. Oh, audio weird is not helpful at all. All right. Let me change my. Sorry, guys. We're gonna switch back and forth real quick. Hopefully that sounds better because I can't hear it. Um, you guys are like kind of robotic sounding. You try something new and then everything goes to hell. All right. Sorry, y'all. See, we tried to bring the music is done. No more music. Sorry about that. All right. Appreciate you, chat. That was strange. Ugh, no more music. We try something new and it's like, rah. All right. It's interesting that Bynes' lawyer says she believes her condition is improved because that is not the same as Britney's attorneys saying, you know, she is changed, the situation has changed. It's much, much different than what was going on in Britney's case. So I will pull the court documents as we go forward if that is if that is something you guys are interested in. So Bynes is seeking to end her nearly 9-year-long conservatorship. The 35-year-old Easy A actress, Easy A is such a fucking great movie. It's such a fucking good movie. She was in lots of other movies though. She's the Man and others that are escaping me, but yes, anyway. Easy A is a fantastic film. Amanda wishes to terminate her conservatorship. She believes her condition is improved and protection of the court is no longer necessary. Bynes' mother was granted temporary conservatorship over her daughter in August 2013. After the actress allegedly set fire to a driveway, not her driveway, someone else's driveway. This past September, a status report regarding Bynes' health was filed and approved by a California court, with the next update scheduled for January. However, the conservatorship was not extended through 2023, and there is a hearing now in March. The lawyer told People it is open day to day. A status report regarding her health and welfare was recently filed and approved by the court. By law, the next status report is due in 2 years. Her conservatorship will terminate when it is no longer convenient for Amanda. Bynes announced her engagement in 2019 on Valentine's Day 2020, and it sounds like she is ready to move on with her life. She is going to FITM to get her associate's degree, which she got in 2019. So it sounds like she is moving forward in her life and maybe is at a point where this is not the option that she needs. So if you guys are interested in getting into a little bit more of what's filed, some of those status reports, because they are dealing with medical information, are naturally and necessarily sealed. But we can pull up some of the motions ahead of the March hearing and kind of tap into or touch in on that story ahead of that hearing in March. So with that, let us move on to the Chalene Johnson case. How many of you have been following this case? Let me know in the chat. Just pop a 1 in the chat if you've been following what's going on with Dr. Laguna and Chalene Johnson. We're going to swoop. But I can't swoop them right. So we're operating all the controls. We're doing all the things tonight. Let's talk about Chalene Johnson and Dr. Laguna. So if you're not following this case, and it's good to see a number of you are following this case, it's been very interesting. I have not touched on it a ton. Chalene has talked about it on her own podcast and in other venues. So with this, Chalene Johnson had surgery with Dr. Laguna, Dr. Malawi, and then started sharing her experience on her podcast on social media without naming the doctor. Then the doctor responded to a comment she left on Yelp and responded by name, and then it just all deteriorated from there. Chalene stated that she was unhappy with the way that he dealt with her as a patient, and has made allegations on social media about what her experience was like, and then has pulled up other patient experiences that were shared with her and highlighted them on social media and her podcast. He then sued her for defamation in California, and we went over that lawsuit, his temporary restraining order, and her anti-SLAPP motion against the temporary restraining order and the preliminary injunction. She has continued talking about this case on her podcast and social media, and then she and a number of other patients filed a multi-plaintiff, I don't know if it's been certified as a class action yet, but a multi-plaintiff lawsuit in the medical malpractice realm, which we have not yet covered, but Chalene has talked about on her own social medias. So with that background of these now 2 lawsuits going on against Dr. Malawi and his business, he filed for bankruptcy. Yep, sure did. Actually, I should pull this up and see if something has happened, because why is this not pulling up well? Because there was a deadline. So I'm going to pull up Pacer too, because there was a deadline for him to file some additional things. So with that, let us get into this bankruptcy, because it's very interesting to see what he filed. So Let me, you know what? Let's go to Pacer. No, me. Should we go to Pacer first? Let's go to Pacer first. All right, we're gonna pull it up on Pacer first, and then we're gonna go. I just want to see if anything's changed on the docket. You get to see me think in real time, real slow, because I do not feel good at all. so, so that's what is going on with my brain. It's like, wait, should we do this? No, should we do that? Wait, should we do this? Yeah. So let me find it because I know I saved it somewhere. And did I not? No, I did. Me debating with myself. I have so many cases that we are tracking. Maybe I didn't. All right. Let's just pull it up. Give me the case. There we go. I did save it. All right. Let's see if anything news happened. We're just going to go to the docket real quick. We're going to do this in just, as I said, it's going to be a real time kind of a show. Oh, good. More things got done today. A bunch more things got done. All right, let's see. What happened since I last checked in? They filed a emergency motion for an emergency entry authorizing the implementation of the procedures to maintain and protect confidential patient information, a declaration in support of the first day motions filed. They set a hearing for February 24th. Okay, so the initial hearing they said happened. Oh, we're going to sneeze. Oh, let's see. So that hearing would have happened. Order setting a hearing of status 11 case, requiring report on status of chapter 11 case. So there was an order from that hearing. We'll take a look at that in a minute. There was another hearing set for April 21st. A meeting of the creditors will be held on March 28th, and that's something that has a telephonic conference line. So we will peek in on that if we can. Proof of service, and then the certificates of things being filed, and an order granting emergency motion to limit notice and notice procedures because there are so many people involved. All right. So with that, let's pull up this bankruptcy and talk about what's interesting about it because it has a few things in effect. First of all, this is a Chapter 11 filing. This is a voluntary bankruptcy. This is not being filed the way that the bankruptcy in the Girardi case is being filed. And this is the initial filing. We're going to get to the creditors. So, have you filed for bankruptcy? No. Are you paying your fees? Yes. Are any bankruptcy cases pending? No. Do you rent your residence? No. Report about any businesses you own as a sole proprietor? No, which means his business is not solely owned by him, which means it could be a corporation. I have not pulled the corporate form, but I'm not surprised that the medical office is not held as a sole proprietorship. That wouldn't make any sense at all. Are you filing as a small business? No. Do you own or have any property that poses or alleged to pose a threat of imminent hazard to public health or safety? No. Received a briefing from approved credit counseling? Sure. All of the things. Here's the interesting things. I'm not filing for chapter 7. Am filing for chapter 11. How many creditors do you estimate you owe? 1,000 to 5,000 is what was selected. Isn't that interesting? 1,000 to 5,000 creditors. How much do you estimate your assets to be worth? 1 million to 10 million. How much do you estimate your liabilities to be? 10 million to 50 million. I think somebody's very worried. This is Emily's speculation, very worried about the civil lawsuit, not that he filed against Chalene, but that Chalene filed against him. The state has also filed against him. And there is also a medical board action going on, but 1,000 to 5,000 creditors seems like a lot. And I can't imagine he would have filed this without talking to an attorney. You would I think this is probably planned. You don't just go, today I'm going to file for bankruptcy, but these are signed under penalty of perjury. Like that has to be signed. I mean, That's a lot of creditors. Um, J Look, J. Scott Williams, attorney. So it's interesting. And then he talks about the different claims. Now, these claims that are going through the law group are plaintiffs that are identified by initial because they are patient plaintiffs. So AG plaintiff, BC, those are all plaintiffs that he has no idea what the damages are going to be. So lists out all of these patients who he believes are creditors who he will owe money to, is what he's telling the court. And we're just going to keep going. CDC, small business finance, bank loans, 738,000. None of the above apply. Does the creditor have a lien on your property? No, that's probably a business loan. But it's interesting that he lists that um, as a personal debt. But he's saying that he's not filing as a small business. So is he might have personally guaranteed a business loan. As this goes forward, we might know more. List Chalene Johnson and her company by name because they are suing him. And then again, this same law group that is being listed for all of these others identified by name or by initial. So we're just going to scroll through the amount and then we're going to get into the debts that are listed. So we've got 700,000 in some kind of business financing. And then no, those are plaintiffs. M&J Star Construction trade debt. I mean, I imagine this is construction on his home. $711,000. These are plaintiffs. All these individuals by initial are plaintiffs. Let's see. Sunbright Pools for $86,000 trade debt. Again, I imagine that this was construction at home. And then the rest of these seem to be plaintiffs. And then he lists all of the lawyer. Then he lists other patients as creditors by number. I want to know why there are so many patient creditors because these are not the plaintiffs from Chalene's lawsuit. So it is confusing to me that there are so many. We're just going to scroll real quick so you can see that there are so many patients listed as creditors. When has your doctor ever given you money back? Patient 1046. So believes that he will owe money, is saying to the court that he believes that there will be 1,000 patients that are creditors. I am so confused. So there is more going on than we know. And it will be very, very interesting to see what is listed and to see what happens in this creditor meeting. Here's the practical effect. Do you guys, my 14-year-old and I have started watching The Office again together, which is so fun to see because he's a theater kid. He's in theater. He loves studying theater at school. And he loves Jenna Fisher's performance in The Office. Like every now and then he will call out an episode and be like, Pam was amazing in this episode. Like I felt it in my soul. Or Dwight made me laugh by being such the literal straight man in this episode. Like he loves watching the acting in The Office and trying to figure out the references to things like the Budweiser was commercials because he has no pop culture contextual reference for things like that. So it's been interesting watching. But in The Office, do you remember when Michael tries to declare bankruptcy? He's like, I declare bankruptcy. Bankruptcy stays all of the pending litigation. Chalene has shared on her social media that they were getting ready for depositions in the defamation case. There are 2 cases. So this stops everything. And the bankruptcy court can bring those civil litigation into the bankruptcy court. This is what the Boy Scouts of America did when they were facing hundreds of millions of dollars in civil lawsuits. They declared bankruptcy and consolidated all of those lawsuits into the bankruptcy. So this will freeze everything that's pending against him, which may be a tactic to cost Chalene time and money. Maybe. But again, you can't perpetrate fraud on the bankruptcy court. So this might be a strategic filing for bankruptcy at this point, but it might also be we're probably not going to win this. And so if we lose as an individual, how much will we owe? Given that there is also an ongoing medical board case over a patient that died. And with that ongoing medical board case, I wonder if, and this is me speculation, I wonder if there is a concern that he will lose his license. And if he loses his license, maybe these are patients that he will have to refund if he can't practice. I don't know. So, but 1,000, like that's it's so much. So I will be following along with this bankruptcy. We will be pulling up the other things going on. I will be following along with the state lawsuit. I'm very interested to see what happens. I have not pulled up the anti-slap. I will just do another breakdown of the plaintiff's lawsuit that Chalene filed and everything else. So the questions I have: why are there 1,000 patients that are listed as creditors, and will they all file a claim? Is this a strategic move because he's concerned about losing his license and therefore will not be able to practice? And will this bankruptcy be granted and force a stay on all of the civil litigation and to pull all the civil litigation into it? Let's see if there's any documents I wanted to pull up in this. Let's see what the emergency order says. Let's just pull that up real quick. Since we can, I just have to remember to download it. So let's see what the court said. We're just going to pull this directly from Pacer because this was entered today. Look at us. Today's the 25th, right? Yep. Today's the 25th. Order granting emergency motion to limit notice and establish notice procedures. The hearing on debtor's emergency motion for all the things I just said above, filed by Dr. Ariane Mallory, I'm trying. The debtor and debtor in possession was heard on February 24th at 10:30 a.m. before Judge Smith. Judge, let's see, United States bankruptcy judge. Attorney appeared on behalf of debtor. Other appearances were noted by the court. The courts reviewed and considered the motion and the attached declaration and the representations and arguments made at the hearing. No objections were raised. The motion is granted. Except provided herein, notices in this case shall be served upon the following entities: the office of the trustee, the unsecured creditors holding the 20 largest claims. So not all of the patients that were listed, the unsecured creditors holding the 20 largest claims, or if a committee of unsecured creditors is formed, the committee. Secured creditors and their counsel, which means people who have a security, credit cards, things like that, probably the pool and whatever. All parties who file and serve requests for special notice, any parties whose interest is impacted directly by the particular action or proceeding noted by the debtor, notwithstanding the foregoing, debtor shall serve all creditors notice of certain proceedings. So it's just to keep the notice list from being those 1,000 patients. So with all of that, this freezes everything going on in the other cases, so we're not going to have updates on those other cases. I'll do a breakdown on the cases I haven't broken down yet, and we'll go from there because that's all we can do at this point because it's going to go into bankruptcy, or maybe it's going to go into bankruptcy. But this is when we talk about strategic bankruptcy. This is one of the things. It's not like Tom Girardi who didn't choose to go into bankruptcy because he was forced into bankruptcy by his creditors. This is a choice, and bankruptcy can be used strategically. We saw that like with the airlines after 9/11, most of them filed a reorganization, Chapter 11, which is what this is, bankruptcy, not a full liquidation bankruptcy. So consolidating bankruptcy, trying to consolidate, I think, all these legal motions. And that's where we're at. So wow. Wowie, wow. That was not something I was expecting to happen in that case. I didn't like that. He sued her for defamation. She sued him. I didn't expect it to end up in a bankruptcy. That's not where I expected that to go. All right, let's see who's next on the docket. Oh, Shah, Maxwell, and Kardashian. All right, let's do Shah, and then we'll take a poll. I'm gonna put a poll up real quick. Let's do Shah, and then we'll take a poll on if we do Maxwell or Kardashian after that. So let me. I need to pull something up so I can do the poll because I need to be in the other type of comment section. So give me 1 second. And of course, I need the chat, but the chat's not popping up on my version of the video, which is not helpful at all because if I can't pull up the chat, I can't put a um poll in it. Chat. The chat is being oh, did I click on the wrong video? Emily, maybe you need to click on the live video that you're on. That would be the most helpful. Do the right thing. Sorry. Y'all, it's like that. It's like that tonight. Oh, as always. As always, it's like that. Give me my chat. Give it to me. Give it to me, baby. Professionals this evening. People, professionals. There we go. We finally have it. We win. I can put a poll. Okay, now y'all have to vote in the poll because we've worked. We have worked. We have worked for this poll. Who's up first? Kardashian divorce. Maxwell. Let's put up that poll. You guys should see it up at the top. You'll be able to vote. I think it's up. There we go. We're just going to pin it. And then I will go end the poll in a little bit. You guys vote while we talk about what's going on in the Jen Shah case. I'm sure some of you have seen reports that there was like fuckery afoot in the Jen Shah case, and we need to talk about that. All right, let us swoopy doop. 5144. 45. Let's swoop. Let's swoop. I have to click to like 3 different places to make it swoop. Swoop. Let's talk about what's going on in the Jen Shah case. It's very interesting for me that this is where we're at. The Jen Shah's lawyers apparently subpoenaed all the other lawyers for all the co-defendants, which is like not the way that goes. And so the co-defendants who have now all pled, Shah is the last woman standing, have all filed objections and motions to quash a subpoena. Motion to quash a subpoena means, hey, I don't have to respond to your shit, man. I don't have to do what you're asking me to do. You did it wrong. Go back and do it again, that sort of thing. There's a reason that you can, or there's various reasons why you can do it. Let's just pull this up and talk about it. So I don't have to keep trying to explain because my brain is so tired because Emily is so not feeling good. Motion and incorporated memoranda of law in support of motion to quash defendant's Rule 17 subpoena to a non-party attorney. Like, I have no idea. I should do a little Shah recap. Road so far. Jen Shah, Real Housewife of Salt Lake City, is the last defendant in a 12-defendant case alleging a large telemarketing fraud scheme, but from that, they are alleging that she participated in a fraud scheme and money laundered. So wire fraud or conspiracy to commit wire fraud and conspiracy to commit money laundering. All of the other defendants have pled guilty. It looks like a lot of them are getting ready to testify against her, including Stuart Smith, her right hand, who has been on the Real Housewives of Orange County with her. We have started going over the motions in limine and enjoying them. And yes, for those of you that are new in the channel, I know it's motions in limine. We have a law-nerd vocabulary because, you know, everybody gets a little like puckery during their motions in limine. It's like, you can't do this, you can't do that. And then we call them motions in limine. I think that's how that started. It just did. It just happened. We have our own thing. So with all of that, they are getting ready to go to trial at the end of March. I very much am considering going to New York and attending this trial, especially for the end of the prosecution's case and Jen Shah's case. Very much considering just appointing myself the official correspondent and showing up to this case all of the time. So with that, they are getting ready for trial. They have done their pretrial motions, and Jen Shah's attorneys tried to subpoena everybody, which, by the way, you can't do. Can't do. Preliminary statement. This is a motion to quash defendant Jen Shah's subpoena directed at undersigned counsel, a non-party attorney who represents one of Shah's co-defendant. The subpoena is both unreasonable and oppressive. As noted infra. Let's see if we can even do a congested footnote voice. As noted infra, Ms. Shah directed identical subpoenas to counsel for a number of her co-defendants. The following counsel received the subpoenas and joined in the motion to quash: Charles Clayman and Thomas Rotako of Clayman, Rosenberg, Kirshner. I'm not reading all of these defendants. I'm going to not read all the law firms. I'm just going to read the defendants. Counsel for Jason Sager, counsel for Anthony Chidi, counsel for Joseph Cercio, counsel for Joseph Minetto, counsel for Ryan Holt. Stuart Smith's counsel has also filed one. The counsel will file letters to the court confirming the joinder in this motion. Should the court prefer independent motions to quash from each subpoena recipient, these lawyers are prepared to file such. Like, does the court really want to read all of these? Do you really want to read all of these? No, you don't. You don't want to read all of these. The subpoena, which is ostensibly being pursued under the authority of Federal Rule of Criminal Procedure 17, targets information related to undersigned counsel's client in his capacity as a potential trial witness. In doing so, the subpoena improperly seeks production of 1, information protected by attorney work product privilege, and 2, non-evidentiary and inadmissible material that should properly be sought from the government through discovery. Yep. Yes, that's an accurate recitation of how that should happen. If these individuals are going to be witnesses against Jen Shah, then the government needs to turn over witness statements to Jen's attorney, not the attorneys for the co-defendants. Why would anyone think that this is okay? This is not the way you do it. This is the opposite of this is how we do it. This is nonsense. Moreover, to the extent that it does not seek otherwise discoverable information, which it does not, the subpoena lacks the requisite specificity to be valid. I hope they add the subpoena down below. I don't know. I haven't looked yet. The subpoena in context marks an ill-conceived effort by Ms. Shah to bypass well-settled law in the district and secure additional impeachment discovery regarding Mr. Hardin in anticipation of trial. Shah is entitled to receive disclosures about government witnesses pursuant to pretrial schedule that is, well, they say maybe already in place, but is already in place. She should seek relief from any such schedule. Go ask the government, Jen. Factual background. Oh, good. I see a couple of you asking, what is attorney work product? Attorney work product is information that the attorney's prepared that is not discoverable. It is confidential work. So whatever she's seeking, and hopefully we'll know more specifically what she's seeking, they're saying is protected because it is the work product of the attorney. It is not something that gets turned over. And to the extent it should get turned over, it should get turned over by the government, not by the co-defendants. I've never even seen anyone try to do this. Like, I want to know how many trials this attorney has done. Like, this is hurting my sinuses. This behavior is making me feel worse. Like, why waste Jen Shah's money to do this? Why? Like, why? Did you think that these other lawyers were just going to be like, yeah, cool, like, we're on your side? They're not on your side. Their clients all pled, and their clients are going to testify against your client. They're not here for you. They're not here for you, boo. That's not how this goes. Maybe I'm just cranky tonight. No, I'm not. This is just nonsense. You guys in the chat are like, maybe Kim K really is part of her legal team. Kim K wouldn't pull this bullshit. She wouldn't want to be embarrassed. So we've got our Real Housewives roller going because I just can't. My sinuses are on fire. And this is just making them angry because that's how it works. Obviously, it's not how it works. Ms. Shaw is a charged defendant in this matter, alleged to have committed violations of federal law. The docket reflects that Shah is scheduled to stand trial beginning March 22nd, 2022. Undersigned counsel represents one of the co-defendants who is charged in the above. On March 24th, 2021, that defendant pled to several charges. His sentencing is set for April 28th. Yes, after. After. All of them are set for after. You know why? You know why they're all set for after? Let me tell you. All of the co-defendants' sentencing, well, not all, a few have been sentenced. Most of the co-defendants' sentencing is scheduled for after the trial because they are going to testify at trial. And then their attorneys are going to be like, look, Your Honor, they cooperated with the government. Give them a lighter sentence. That's how that works. Ugh. It is possible that Mr. Hardin may be called as a witness in Ms. Shaw's trial. Oh, I'm sure it's possible. On or about February 8th, 2020, I want to see Stuart Smith testify so badly. That's what I want to see. On or about February 8th, 2022, counsel for Shah sent a process server to the offices of undersigned counsel, presumably to serve the subpoena. And they all looked at the process server and went, excuse me, what the fuck is this? What is happening? What are you doing? No, don't do it. While surprised, I imagine it went like, what the fuck is this shit? What are they doing? We're not doing this. While surprised, we immediately contacted Ms. Shaw's counsel and agreed to accept service via email of the subpoena as a professional courtesy. The subpoena demands production of, tea. All documents and communications between you and a member of the U.S. Attorney's Office concerning this matter. What the fuck? It's so overbroad. And those communications are work product. No. Oh my God. This is not a civil, first of all, this is a criminal case. Second of all, you couldn't do this in a civil case. Like, no. All documents and communications between you and any law enforcement agent. Counsel, can you tell me if you talk to the feds on behalf of your client? Stop it. All attorney notes or other, Jesus, you know that's work product. What is, were they serious? Are they just burning money? Are they just burning money? They're just like, hey, Jen Shaw will pay for it. What the, no, maybe this is where the $2 million retainer is going. Did Jen Shaw really pay a $2 million retainer for this? Or is she lying on the show? Why you won't? Anyway, all attorney notes, there's no fucking way that's ever going to happen, and other documents prepared by you from each proffer session attended by defendant in this matter. This has got to be a joke. Proffer sessions are when the defendant and their lawyers sit down with the government and are like, look, if you could give us this sentencing recommendation, we could tell you this. I see y'all making motions for DEFCON red. I feel like this is the kind of fuckery that deserves DEFCON red. They're subpoenaing things they can't subpoena, and in good faith, I don't know how they could think that they could subpoena this. Like, how do you ever think that this is okay? This is never okay. You can't do this. This has got to be a joke. But let's go to DEFCON red. I'm going to give a warning. For those of you that are flash sensitive, this is flashy. It will end when the music ends. So if you need to minimize the window so you can hear it, or look away or cover your eyes, it's flashy. It's going to flash, and we're going to do that in 3, 2, 1. We are red. Because this is some bold bullshit up in here. Attorney notes. Attorney notes. Who's asking for attorney notes? Oh my God. It's so bad. Ms. Shah unilaterally selected the return date for the subpoena as February 22nd, 2022. 22222. We just liked the numbers. I liked the numbers. I like numbers. Undersigned counsel spoke with counsel for Ms. Shah. Ooh, tell me. Tell me what you said. Undersigned counsel spoke with counsel for Ms. Shah to discuss concerns about the appropriateness of the subpoena. Excuse me, counsel? WTF. and was advised that she would seek enforcement of the subpoenas absent compliance by the return date. Why? The court's gonna be like, negative, ghostwriter. After our receipt of the subpoena, we learned that several other lawyers who represent potential trial witnesses in this matter were contemporaneously approached by process servers at Ms. Shaw's direction. Each of those lawyers are now in receipt of subpoenas directed at them as counsel for their clients, seeking verbatim the information requested of undersigned counsel in the subpoena with respect to their clients, setting the return date of 2/22/2222. Undersigned counsel has conferred with those lawyers about the appropriateness of the subpoena. Oh, what do you think that phone call was like? All of the attorneys together being like, Emily, dramatic recitation and wild speculation of what that phone call was like. Counsel, are you present? Yes, we're present. Anyone recording? We're not recording. Okay. What in the fuck do they think that they are doing? This is the most bush league bullshit subpoena I have ever seen. Do you think she realized she should have pled guilty by now? Because what the fuck is even happening? Who wants to write the motion? Well, I agree to write the motion. Do y'all want to join in the motion? Sure. This is the grounds we're going to argue it on. Does anyone have any other input? Great. I'll send it to you by email because this is really some bullshit. Oh my God, I want to be in court the day that the judge rules on this because they're going to be so mad. I think that's probably a recitation of what happened. That's Emily's dramatic and wild speculation. But I imagine that shade was thrown. Ms. Shaw's subpoena request without discussing any confidential and or privileged information concerning clients. In the interest, yes, of course they didn't discuss their own clients. They discussed Ms. Shaw. In the interest of efficiency and hopefully to lessen the burden on the court of dealing with this epic bullshit, we agreed that this motion to quash on behalf of Mr. Harden and other counsel who join and adopt this as their motion argument. The subpoena is a transparent effort to both intrude on attorney work client and to impose unwarranted burden on potential trial witnesses in advance of trial. Jen Shah doesn't want any of them testifying against her, but she's not going to be able to stop that from happening short of pleading. Moreover, as Ms. Shaw's counsel, sophisticated and experienced criminal defense practitioners in this district as well. How? Look, so who made this decision? If her counsel are sophisticated and experienced criminal defense practitioners in New York, how did they decide with a straight face that this was a good idea? This is just going to piss off the judge. Here's what you don't want to do ahead of trial. Piss off the judge. This is a strategic attorney decision. Jen Shah could be like, get this information. And the lawyers are going to be like, okay, we can request that from the government. Here's when they have to turn it over by. This is not something that you should ever request. Why? I need answers. I have questions. Ms. Shaw's counsel, apparently sophisticated and experienced criminal defense attorneys, are well aware that the subpoena constitutes a premature and invalid end run of the standard disclosures ordered by the court and government, and it should be quashed. Let's see. Under Rule 17C2, the statute invoked by Shah for the subpoena, Shah bears the burden of showing that the materials requested are relevant, specifically identified, admissible, and not otherwise procurable by the exercise of due diligence. Those have to come from the government. A defendant may only obtain evidence through Rule 17 if she can clear 3 hurdles, namely by meeting her burden to establish relevance, admissibility, and specificity. All your notes is not specificity. The subpoena improperly seeks work product. Yep. We're not going to go through the law because yep. The subpoena improperly seeks inadmissible and irrelevant material. Yeah, all of the proffer sessions are inadmissible. If they have a witness statement, that'll get to Jen Shah before trial. The subpoena's insufficient specificity. All is not specific. The subpoena seeks material that must be obtained, if at all, through discovery from the government. I agree with their headings. For the foregoing reasons, this should be quashed. Let's see what the court's done. Let's see what the court has done. If the court has done anything. Let's see. This is a memo endorsement. Is this from today? No, this is from the 23rd. All of the defendants, so all of the other defendants filed something like this that said, I received the subpoena and join in the motion. So they're all joining in the motion to quash because, of course, they are, because that's what you do. Let's see if the court did anything today on this real quick. It's just so wild. And there was a sealed, let's see, there's a sealed docket placed in the vault today. And then yesterday there was a memo endorsement granting 484 letter motion. Let's see what the memo endorsement is. Real time. This is just another attorney asking to join in the motion to quash. I represent Jason Sager. Sager is a defendant. We'd like to join in the pending motion. The subpoena calls for the production of documents by February 22nd. Several other law firms have identified. We write to advise the court. We join in the motion to quash. So we all join in the motion to quash. Hopefully the court will just quash this next week. I can't imagine that they won't. I wonder if they're going to I wonder what the court will say. I'm very curious. I think this will get quashed. I'm very interested into what got placed in the vault too, but we don't know because it's, sealed. So a whole bunch of defendants just said, we join. And that's what's happening with Jen Shah's attorneys. Though, here's what I'm excited about. Maybe it's just going to get spicy as we run up to trial. I mean, we saw a lot of spiciness in the motions in limine running up to Duggar's trial. We saw that crazy assertion of penitent privilege, which was crazy and amazing because we learned so much. It just kicked the door wide open. So, I mean, the court's going to quash these subpoenas, and by quash it means squash. Like, I always think of it like squash. It's going to like the subpoenas. Like, no, that's not enforceable. You can't have any of that. So I always think of a motion to quash as like literally squashing the subpoena. Like, you can't do that. So your subpoena is not enforceable. So they sent a subpoena. Everybody objected, and the court's going to say your subpoena is not enforceable. You don't get what you're asking for. Squish. Because again, when I was in law school, quash always sounded like squash to me. It's a motion to squashing the subpoena. All right, let us move on to other fuckery that is afoot. I'm going to go to the poll. You guys voted. Ooh, 65% Kardashian divorce. All right, y'all. That's where we're going next. We're going to end that poll right here. And the chat has voted. So replay crew, the chat has voted heavily that we are going to the Kardashian West divorce next, where Emily was so wrong. So wrong. Oh, they have a solid prenup. It looks like the attorneys are working behind the scenes. This should just be pro forma. It'll get signed off. They'll be divorced. Nope. Not what's happening anymore. All right. I'm gonna sneeze. Oh my goodness. We did a double swoop to cover up my sneezing. All right. Let's get to what's going on in the Kardashian West divorce. For those of you that have not been following this, fine. There's the quick background is that Kim Kardashian West filed for divorce. They said that they had a pretty thorough prenup. With the pretty thorough prenup, it looked like they were going to just go through the prenup and enforce those provisions. And then in December, things started to get weird. And Kim Kardashian filed a motion. Let me pull that one up first because the reason I'm pulling up the December motion is because it gives context to what's going on now. And what's going on now is that, well, we've seen Kanye being all Kanye-y on social media. A lot of it I just don't agree with. You don't threaten you don't threaten the person your children's parent is dating, and you act like adults. But Kanye also feels like Kim is holding the kids from her based on what we've seen on social media. So let us just go to what's happening in court without all of what's happening on social media, because the court documents are what we're relying on. And I have not kept up on everything that's going on social media. Divorces are hard when there are kids involved. And I always end up just feeling badly for the kids when the adults cannot just break it down. So with that, in December 13th, Kim Kardashian, through her attorney Laura Wasser, filed this motion requesting a bifurcated or a separate trial. All right, we are done with the hot water. Now we've got to move to just the regular water. We're going to need all the water. So they asked to bifurcate the trial, and we're going to talk about what that means. They're asking for a separate trial on the termination of marital status. Chat, if you know, I have no idea when Kim Kardashian kind of went public with Pete Davidson. I don't know if it was around this time or not, but in December, she was asking to bifurcate the trial. And what that means, we'll go through a couple of the other check marks that matter, but it generally means that she's asking to be declared divorced or legally divorced and single, and then they can continue to deal with any disputes over property, custody, and those sorts of details. So it's asking to separate the two issues. Deal with the property separate. Please let me free from this person. So we're going to go through just a few of the things. Other orders requested. Petitioner requests an order to bifurcate the issue of marital status from the remaining issues of this case and to terminate the parties' marital status at a hearing on such request as set forth in the proposed status-only judgment attached to Exhibit A. Petitioner has no objection to the court imposing any conditions that are deemed appropriate and necessary. Declaration of Kim Kardashian and the attorney. And we're going to look at those declarations real quick. These are not the newest ones. These are from December. These are giving context. Division of property. Petitioner, respondent, and his or her estate must indemnify or hold the other harmless from any taxes, assessments, interest, and penalties. Health insurance. These are all the other things that are being dealt with. Like, these all need to be dealt with. And these can be other other statuses that are fine. But this is what we're asking for. Jurisdiction over issues other than marital status is reserved. Memorandum of points and authorities. Petitioner Kim Kardashian West submits the following. The court has jurisdiction to bifurcate. They do. The court may do that. It's not odd that they wouldn't. They're saying that it's an abuse of discretion to deny the motion to bifurcate absent compelling reasons. And this is citing case law saying that absent a compelling reason, denial of a motion to bifurcate is an abuse of discretion. Like, if they're fighting over property, let them free, and then they can fight over property. Thank you, chat, for saying they started dating in November. The court should grant the respondent's request to bifurcate. And let's see. Declaration of Kim Kardashian West. I'm petitioner within the matter. I have personal knowledge of the following. I submit this declaration and request for an order bifurcating termination of my status of marriage to respondent, Kanye West, hereafter respondent. All allegations in my petition in this matter are true. I've been a resident for California for over 6 months prior to filing. There are 4 minor children of the marriage. I'm requesting the court bifurcate. A true and correct copy of my proposed status-only judgment is attached. Respondent and I were married on May 24th, 2014. Prior to the date of our marriage, respondent and I entered into a premarital agreement. Prenup, people, prenup. Respondent and I were married. Prenup. I filed petition for dissolution of marriage on February 19th, 2021. Respondent filed his response on April 4th, 2021. I served my preliminary declaration of disclosure November 24th. Respondent has not yet served that. I have no objection to providing respondent with the protections available to him under the law. I do not have a retirement or pension plan that would require joinder. Irreconcilable differences have existed and continue to exist between respondent and me, which have caused our marriage to my brain has just completely stopped, irretrievably break down. No counseling or reconciliation effort would be of any value at this time. There will be no prejudice to respondent if our marriage is immediately dissolved, especially given the fact that throughout our marriage, we adhered to the terms of our premarital agreement and maintained a separate property character of our assets. I've been attempting to settle our dissolution with respondent since I filed for divorce in February. I've requested several times that respondent agree to bifurcate and terminate. Respondent has not responded. Well, we know from social media that Kanye he doesn't want to get divorced. Respondent and I both deserve an opportunity to build our new lives. Therefore, I'm requesting to bifurcate. So that was executed right around Thanksgiving and then was served. The attorneys are like, we've done all the things we should do. We filed for the dissolution of marriage. There's the dissolution petition that we already went over. Kim is ready to be single and not be responsible, I think, for the things that that's going on with Kanye, and maybe so that she can date. I don't know. Maybe so it can be done. She filed for it in February. It's been a year. The normal waiting period is 6 months. And she's like, after a year, I would like to be single and we can deal with the property separately, which they can. So let us get up to speed on where we are now. Kanye filed, and then Kim filed. Kim filed an extensive declaration. Let's see. Where is the extensive declaration? That's not that one, which is what I'm looking for right now because, we're super organized up in this piece today. Where is it? It was just recently 223. There it is. All right, we're going to pull up Kanye's first, and then we'll go to Kim's. So Kanye's response filed on February 16th. This is followed by his attorney, Christopher Melcher, who you guys probably know from watching other channels, Popcorn Planet. He's done Britney coverage and stuff. He is a family law attorney. So he is the attorney for Kanye West. This is regarding the March 2nd hearing date on the matter of bifurcation. So on the matter of bifurcation only, can they split it and declare Kim legally divorced and then deal with the property, which shouldn't be taking that much time because they all held their property separately and there's a prenup, which is why I said this shouldn't be crazy. So, we'll see. We'll see what happens. They kept all their property separate. If it's all separate property, it shouldn't be hard. But that doesn't mean that if Kanye hopes that his family's going to get back together, that he will drag it out. So let us continue with the checkboxes here. Other orders requested. I do not consent to the order requested. So it's an objection to Kim's request to bifurcate. Facts support. Response to request for separate trial. Memorandum of points and authorities and declaration is attachment 10. Dissolution of the status of marriage or domestic partnership. I will serve respondents' preliminary declaration of disclosure and have completed schedule of assets and debts. Any pension or retirement plans which the community has an interest are listed. Those are probably his because Kim is saying she doesn't have any. Those get hotly fought over in the divorce proceedings. Sloan, it's good to see you in the chat. Hello. I know things are wild. I will, at a hearing, ask the court for a separate date for trial. So they're objecting to it. Division of property. Petitioner and his or her estate must indemnify and hold respondent harmless for any taxes, assessments, penalties, which they've said, like, these are things they've agreed on that we've gone through in the other reading of some of these petitions and aren't the most important for us. Other conditions, petitioner Kim Kardashian West to waive the marital privileges under Evidence Code 970, 971, 980, and to obtain a waiver of such rights from any new spouse prior to remarriage until a final custody determination has been made. So they're asking that if this is granted, there's additional orders made. Any right of reimbursement under Family Code 2640 by Respondent West is preserved. Petitioner Kim Kardashian will not transfer assets out of any trust, but will defer receipt of any benefit or other right that occurs under a trust and result of status being terminated until there's a final judgment on property. Those aren't unreasonable things to ask for by any means. It's just asking that nothing be done with the property until it's determined. But still, it's been a year. If she wants to be divorced, let her be divorced. I don't see how not allowing it to bifurcate helps anyone in this situation. I just don't see how that helps. That's not helpful either. When you know your streamer doesn't feel well, it's when everything just kind of is a little awkward. Memorandum of points and authorities. Terminating marital status before custody, property, and support issues are resolved creates a risk of adverse consequences. Even though Kim was like, look, literally, I will, whatever, Whatever protections need to be put in place, we're good with. Just please do this. This is especially true if one of the parties were to pass away while the case is pending. Though they could do an intermediary trust or will to prevent around that. An early termination of status also creates barriers to obtaining evidence if a party remarries before the case is concluded, which I will just, with the shade, I will just say, Kim has been married a lot. That's just a fact. I can see where their concern is. I hope that Kim does not just turn around and get remarried. Counsel for Respondent West, whose legal name is now Ye, like YA, right? Kanye, Ye, whose legal name is now Ye, attempted to informally resolve these conditions and address errors in the proposed status-only judgment. Some issues were corrected, but significant problems remain. The court should deny petitioner's request for a separate trial on the termination of marital status because the motion does not provide the protections necessary for an early termination of marital status. Statement of facts. On January 20th, 2022, Ye's counsel wrote to Kim's counsel identifying the following procedural issue with Kim's motion and proposed judgment. 1, Kim's preliminary declaration of disclosure does not include tax returns as required by Family Code Section 2104. Kim did not include an interim order regarding her retirement plans. She said there weren't any in her motion that we just read. In the proposed judgment as required, Ye's counsel obtained Kim's proposal for mutual indemnification of any consequences resulting from the early termination, asking Kim to indemnify Ye against those consequences. She was the one, as she was the one asking for the early termination. Ooh, let's hear what happened. Let's hear what happened. On January 28th, 2022, Kim provided the tax returns. Kim's counsel provided a new version of the proposed judgment. On January 28th. On February 9th, 2022, Ye's counsel, wrote to Kim's counsel explaining that the revised judgment states that separate orders are attached regarding Kim's retirement plans and non-probate transfer assets, but no such orders were attached. Ye's counsel also requested the additional conditions. So let's look at the conditions. That Kim waive marital privileges in the evidence code is listed above. That any right of reimbursement Ye has under Family Code. I have no idea what happened. I have no idea what just happened. If it blanked on you, I'm sorry. It was like Chrome just reset itself. It was like, what? That any right of reimbursement that Ye has under Family Code 2640 is preserved if either party dies before a final judgment is entered. That Kim will not transfer assets out of a trust. On February 15th, 2022, Kim's counsel rejected these additional conditions and provided a revised attachment of judgment. Kim's counsel asserted that the removed conditions are not applicable because the parties have a premarital agreement. Hey, this has been decided already. We don't need to do any of this. This has already been decided. Discussion. A court may grant an early and separate trial on the issue of dissolution of status of marriage apart from other issues, but the right to an early divorce is not absolute. Certain conditions are required. And then they say these are the certain conditions. Mandatory orders regarding retirement plans have not been proposed. Again, Kim is saying she has no retirement plan. And if she has no right to his retirement plan, I don't know why that's a sticking point. The court should impose conditions to protect the family's financial status quo. The premarital agreement is irrelevant. The conditions in sections 2337, subdivision C and 7, maintain the financial status quo until all property has been characterized. And they're saying, no, it doesn't go by way of the code. It goes by way of the premarital agreement. Kim is restrained from changing beneficiary designations on non-probate transfers because of the automatic temporary restraining orders that are in place. We talk about the automatic temporary restraining orders in next week's podcast as we talk about the Jolie Pitt winery fuckery, because the automatic temporary restraining orders that go into a place that kind of freeze, almost like a bankruptcy, it's a rough analogy, freeze what's happening with the property while the divorce is ongoing. That was what was going on there when the winery got sold, and those were lifted because the divorce had been going on for so long. They say if it turns out that there is no community interest in any of the IRAs because of the premarital agreement or otherwise, there would be no harm in imposing the condition. If the court grants Kim's motion, it should not. It should at least impose these conditions to preserve the financial status quo. Additional conditions proposed by Ye should be granted. The court may impose other conditions it determines just and equitable. 3 additional conditions are requested. We listed those above. The Family Code 2640 condition, the court should preserve the right of reimbursement. The conditions necessary because reimbursement under the Family Code expire upon death, so it's protecting in case somebody passes away during it. The trust condition, stopping Kim from transferring anything. It depends on how many trusts there are. So, but if the trusts are the things that are already in the premarital agreement, that shouldn't be a difficult sticking point. This is not an extravagant request. Kim's counsel has asserted that this condition is unnecessary given the premarital agreement, but I see the point. If it's unnecessary, then what's the harm? Like, if it's unnecessary, then what's the harm? Just put the condition in there. Okay, fine, it's unnecessary. Go ahead. Just put the condition in. If you want this to get done, just work with us. I can understand that argument. The marital privilege condition. The last condition requested by Ye was that Kim waive the marital privileges under Evidence Code 970, 971, 980 until a final custody determination has been made, and Kim obtained the same waiver from any new spouse prior to privilege. These are the privileges that they are listing. 1, not to testify against their spouse in any proceeding. So he wants to be able to put stuff out on blast, it sounds like. Hey, waive the privileges so I can testify against you. And I think, this is speculation, I wonder, I will posit that he wants to do that because he wants to be able to tell the court about what's going on, or be able to testify against Kim while they're arguing these things, instead of waiting for the court to declare them divorced to do it. Interesting request. I just wonder what's behind it, and we won't know until we know. So these are the spousal privileges: not to testify against a spouse, not to be called as a witness in which their spouse is a party, not to disclose marital communications. Exceptions exist for testimony related to income, expensive assets, debts, and employment when a dissolution is pending between spouse and former spouse, and the property and debts of the marriage have not been adjudicated. So they're saying no such exception exists for the Evidence Code, Section 980. Furthermore, there are no exceptions in testimony relating to custody. Keep reading, Emily. Bing, 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 bing. Keep reading. Testimony regarding custody, even when no custody determination has been made. So he wants to be able to tell the court what he thinks about Kim when it comes to custody. And that can't happen unless they're divorced or it's waived. If status is terminated now without this condition, then a barrier to obtaining evidence regarding parenting and custody will arise if Kim remarries before the case is concluded. Kim's motion should be denied, they say. Let's go to Kim's motion. Kim's got a reply. Kim has more to say. Oh, my nose. I apologize, y'all. I will be. Sorry, y'all. I muted ahead of my schnoz pause, but we had to take a schnoz pause. And now we are back. Hopefully that's better. So, schnoz pause. Memorandum of Points and Authority. This is the response to what we just went over briefly. Respondent Kanye West's efforts to impede petitioner Kardashian's request to end their marriage. It's interesting to me, by the way, that they do not call him Ye. They're just not responding. They're just not responding. They're just not calling him Ye. So West's efforts to impede Kardashian's request to end their marriage through the what? Strategy. We're going with strategy because my brain is tired. And why are we using stratagem? I guess it's multiple strategies. Is stratagem the plural of strategy, not strategies? Maybe. I don't know. Perhaps. The stratagem of demanding the court impose onerous conditions not sanctioned by the family code should be rejected. Mr. West asserts without a scintilla. Oh, we love scintilla. Without a scintilla of evidence that terminating marital status based on this statutory protections found in section 2337 does not provide the necessary protections. He provides it no such evidence, including in the form of a declaration, because it is not true. Since filing for divorce, Mr. West, by his actions, has made it clear that he does not accept the parties' marital relationship is over. I mean, I feel like that's fair. Mr. West has disseminated on social media the parties' private communications. Oh, that happened. Yep, that sure did. He was putting in the screenshots between the two of them. So, yep. Mr. West had disseminated on social media the parties' private communications and misinformation about personal family matters and co-parenting, which caused emotional distress. Terminating marital status should help Mr. West to accept the parties' marital relationship is over and move forward on a better path, which will assist in peacefully co-parenting the parties' children. Delaying in doing so will only create further tension and anxiety. Miss Kardashian sought Mr. West's agreement to bifurcating status before she filed her RFO, and she continued to do so post-filing. Kardashian agreed to make certain when I try to say changes and status at the same time, tried to make certain changes to status-only judgment requested by Mr. West's counsel, attaches Exhibit 1, the revised status-only judgment. Status-only judgment, by the way, means that it changes the marital status only. It's one of the times in law when it actually, the thing means what it says. It changes the status from married to divorced, changes them to legally single, and doesn't touch the custody and the property. Mr. West now demands 3 new conditions not sanctioned by the family code. Mr. West has made no showing that any one of these 3 non-statutory conditions are necessary to protect his interest or protect the status quo, nor could he. That's because the parties entered into a prenuptial agreement that governs, inter alia, the character of the assets, debts, income, and rights of reimbursement. Mr. West should not be permitted, in the guise of imposing conditions on terminating status, to rewrite the terms of the parties' prenuptial agreement. There are no community property, assets, or debts. I mean, if there aren't, then there aren't. Mr. West does not claim otherwise. The parties' prenuptial agreement plainly provides that 1, no community property shall be created during the marriage except in the matter set forth in the agreement, to wit, real property taken in joint name as community property, which they did not do, I believe. Keep reading. There's a footnote, Emily. The prenuptial agreement states that the only form of community property that can be created is if the parties purchase a real property in joint name as community property. This never happened. No, but confusingly, like one of them bought the land and one of them owns the house. But okay, rich people shit. 2, that all of Miss Kardashian's and all of Mr. West's earnings, compensation, and income during the marriage shall each be their respective separate property. The parties also expressly waived Family Code 2640 reimbursement claims, except for 2 specified reimbursement rights. Ooh, let's go to the footnotes. What are the reimbursement rights? The only reimbursement rights not waived were capital expenditures for jointly owned real property, of which there is none. Well, that makes it pretty easy then, doesn't it? And capital expenditures, if any, regarding one piece of real property Miss Kardashian owned at marriage. Okay. Right of reimbursement. You know who could have used a right of reimbursement? Brad Pitt and Angelina Jolie, because he sunk millions into that winery and she went and sold her interest. He's not happy about it. But again, I get ahead of myself. All right. They say that the parties expressly waived. We did that. That they agreed on the. They agreed that in the absence of a written separate property reimbursement agreement, any separate property contributions were deemed to be a gift. So if he bought her something expensive, if she bought him something expensive, if she invested money into his thing or he invested money into her thing, that those are just a gift. It's like if we don't write it up, you don't get reimbursed for it. It's a gift. Mr. West's counsel represented to Ms. Kardashian's counsel in writing on October 2021 that to their knowledge, Mr. West had no issue with the validity of the prenuptial agreement. Oh, interesting. Here's the tea. Quote, I can assure you that as far as we know of no issue that our client has regarding the validity of the PNA. So there is nothing for us to say in that regard. But as you also know, we face challenges in communicating with our client. Oh my. And the validity of the prenup, with all of its related legal implications, is a heavy issue to broach. If the goal is to obtain status only judgment expeditiously, I suggest that we do what we can to minimize the need for legal explication. Removing paragraph D accomplishes that. We can still bifurcate status and ratify the prenup later. Yeah. No additional conditions necessary to protect Mr. West's property interest because there is nothing to protect. There is no community property. There are no joint titled assets. Footnote 4. They have one joint checking account that was used to pay for certain common living expenses and the children's expenses. Per the prenuptial agreement, all monies deposited by each into such bank accounts remains his or her separate property. Upon divorce, the funds are to be distributed on a pro rata basis on their separate property contributions, which wouldn't be hard to trace. You just go look at the bank statements and see which account it came from. Um, that's not hard to ascertain. They say Miss Kardashian's assets, all titled in her name in the name of revocable and irrevocable trusts and entities, are her separate property, as agreed to in the prenuptial agreement or the PNA. The same is true for Mr. West. Mr. West does not deny in any of his responsive papers, or does not deny this. In short, the notion that he needs protection is beyond the temporary restraining orders or statutory conditions. They're saying is unsupported by evidence, because if everything's separate, then he has no right to it down the road. So if everything's separate, he has no rights to it. So why would there be conditions protecting it? Because he has no rights to it down the road, so it doesn't matter. Mr. West's counsel's bold statement that the party's PNA is irrelevant does not make it so, nor does Mr. West or his counsel explain why this is so. The legislative purpose of the Family Code Section 2337 conditions is to protect a spouse who does not have access to and or knowledge of the assets and property held in the marital estate. Well, Kanye knows what he holds and Kim knows what she holds. So everybody's good, is what they're saying. They're saying that the premarital status is the status quo. We appreciate, Miss Wasser, we appreciate the bolds. It makes it much easier for us to just kind of scoot through. They said consistent with the premarital agreement with a prenup. I'm just going to start saying prenup because it's easier. Ms. Kardashian's petition for dissolution of marriage and West's response each request that the court terminate their ability of either party to receive spousal support, and both requested that the court order each party to pay their own attorney's fees. Well, that's not hard. They're saying that it is, here's the shade. It is Mr. West's, quote, bitterness and unhappiness that Ms. Kardashian seeks relief from. Ms. Kardashian has met her burden. Mr. West has not. Mr. West submitted no declaration explaining why the court should not enter a status-only judgment or providing the court with any reason why his additional non-statutory conditions are necessary. Mr. West does not dispute the enforceability of the parties' prenup. Mr. West does not assert that any community property was created during the marriage, let alone community property or rights that need to be protected, separate from the ATROs. Miss Kardashian acknowledges that the court has discretion to impose the statutory conditions listed in the Family Code to the extent it deems them necessary and has agreed. Mr. West fails to meet the compelling evidence standard, so they're saying he, as a matter of law, he didn't reach the standard, that Mr. West does not reach the statutory conditions. Let's see. We're not going through much more of this because it's going to be saying the same things in different ways. The waiver of marital privilege condition is the interesting one to me. They're saying that West demands a condition to bifurcate, that Miss Kardashian waive all marital privileges should she remarry, and that she must obtain a waiver of privilege. They say this is unprecedented. Mr. West cites to this court no authority permitting the forced waiver of these evidentiary privileges. Mr. West's goals here is to prevent or make it difficult for Kardashian to remarry. Well, that might be true. We know how he feels about her boyfriend. I can't imagine after all of this that Kim wants to get remarried. That's just my wild speculation. But I would imagine it would be like, we can do all the things, but we good. Mr. West makes no compelling showing that this condition is necessary to protect his interest or is just or equitable. His counsel simply posits that the marital privilege would be a barrier to obtaining evidence regarding parenting and custody. Clearly, the legislator does not see the necessity of including a forced waiver of marital privilege as a condition of terminating marital status. Finally, Mr. West is requesting that the court make orders affecting a third party, some possible future spouse, who is not before this court. Mr. West cites to the court no authority that authorizes the court to require the waiver of marital privilege of a person not a party to the action. And then there's another declaration of Kim Kardashian. Let's see what Kim had to say. I very much desire to be divorced. I have asked Kanye to keep our divorce private. He has not done so. Kanye has been putting a lot of misinformation regarding our private family matters and co-parenting on social media, which has created emotional distress. I believe that the court terminating our marital status will help Kanye accept that our marital relationship is over and move forward on a better path, which will assist us in peacefully co-parenting our children. Before we were married in May 2014, Kanye and I entered into a prenup. We were both represented by our own counsel in connection with the negotiation and execution of the prenup. I have redacted the financial statement attached as exhibits A and B to our prenup in order to protect my and Kanye's financial privacy interest. Both Kanye and I came into the marriage with significant with significant separate property estates. We each wanted to protect our premarital assets and earnings from those assets and any appreciation in the value of our premarital assets during our marriage. Our prenuptial agreement so recites. I mean, that makes sense. Kanye and I also discussed and agreed that during our marriage that his earning compensation and income would remain his separate property and that hers would remain hers. Our prenuptial agreement memorializes this agreement. Kanye and I also agreed during our marriage that all assets and property that I acquire would be my separate property and his would be his, with one exception. Section 7.8 of our prenup states that if Kanye and I purchase real property together and take title in our joint names as community property, we agree the property shall be characterized as community property. But they never did. Kanye and I have no community property or debts. We did not jointly acquire any assets or property during our marriage. Assets I acquire are in my name, the name of my trusts, or in the name of the businesses I own, and those are separate property. Assets Kanye acquired are his, and those are his separate property. Our status quo now and throughout our marriage is that his assets and debts are separate, and her assets and debts are separate. We also expressly waived Family Code Section 2640 reimbursement claims and agreed in the absence of a written separate property reimbursement agreement, any separate property contributions would be a gift. So this is reiterating all of what is stated already in the motion above. I own multiple parcels of real property, multiple giant tracts of land. I own multiple parcels of real property and revocable trusts I created. I hold title to a number of checking and brokerage accounts in trust. I hold substantial insurance assets in trust. I own significant business interest in trust. I'm the sole settler and trustor of all revocable trusts of which I hold my assets. Kanye is not a settler, trustor, or trustee of any of my trusts. So he can't freeze the trusts, is what she's saying. How hard is it to say trusts like a day after you get Invisalign? Hard. It's hard, people. Trusts. Today it's difficult. If the court was to grant Kanye's condition to bifurcation that I be prohibited from transferring any assets in or out of my trust and freeze my right to receive the benefits flowing from my trust, my ability to live and conduct business would be in large part frozen. I would be precluded from conducting business, paying my business or personal bills and obligations, and managing financial affairs. Well, that explains why she's fighting over it. That makes sense. I would be restrained from having access to my own separate property assets. This is what Kanye and I agreed to when we executed our prenup. We agreed in the prenup that we would each have sole control and management of our separate assets. I understand that Kanye and I are subject to the ATROs. I will abide by the ATROs during the pendency of this case. While I wish our marriage would have succeeded, I have come to the realization that there is no way to repair our marriage. Kanye does not agree, but at least it appears that he has come to the realization that I want to end our marriage, even if he does not. I ask that the court restore me to the status of a single person so that I can begin the healing process and so that our family can begin the healing process and just move forward in a new chapter of our lives. Signed by Kim Kardashian West. I wonder if she's going to rename all of her business. I don't know. Maybe. And then declaration of Laura Wasser is saying, yes, we did this. Here's the contact with Christopher Melcher. Here's the communications. This is what we did. And this is all contained in the motion above, so we don't need to go over it again. And then exhibit 1 is their motion for bifurcation. Is there anything else we haven't gone over? I don't think so. Exhibit 2 is the prenup. If you guys want me to go over the prenup, let me know and we will go over a prenup on another day. It is not, it is the details of which have been lined out. The financial stuff is going to be lined out of here. So that's a copy of the prenup that's attached that they're still fighting over. But we are not going over all of this today because we need to get to their stuff. If you guys are interested in a breakdown of their prenup, oh my God. If you're interested in a thorough breakdown of their prenup, let me know. But we're not going to get any financial tea because that's all been redacted out, which is appropriate. They all own a lot of shit, but they're proving all the stuff that they talked about is in here. Look, we agreed to all of this. It looks like they have only one. Where's the other signed copy? They need the executed copy by both parties, but hopefully they have the executed copy by both parties. Let's get to the end and see. Oh my God, it's still going. So it doesn't look like they have the copy executed by Kanye, which is interesting. They should have it somewhere. Yeah, oh, there we go. It was executed separately. So there you go. All executed. It's so long. That might make you not want to get married. The length of that prenup might make you change your mind. I'm being cheeky. So notarized and exhibit A. All right. Then exhibit A would be the financials, and the financials are all redacted. just redacted. So that is it. All the property they own. We don't need to go over it. It's all redacted. We need to get to the Maxwell case and then do some questions. Me, it should be a short night. Also me, it's 2 hours in and we're starting a new topic. Thank you, mods. Thank you, law nerds, for putting up with my horrible voice because I don't feel good. It's time to talk about Maxwell. It is. YouTube's gonna love this so much. Thanks, YouTube. Let us swoop. Oh, my sinuses are just like. Anyway, my sinuses are mad. Y'all, if you were here on Tuesday, you know how much legal stuff is happening in the Maxwell case. Literally, it's so much. It's so much. I'm going to try to distill. Maxwell went to trial. She was convicted of most of the counts. After trial, juror number 50 gave an interview and made some statements about sharing with the jury their own experience with SA and SA as a child, and that helped the jury understand and come to their decisions. After that those interviews, the government filed a motion with the court and said, "Excuse me, Your Honor, it's come to our attention that Juror 50 has made some statements to the media indicating that they had these experiences," and I covered that, which is on the Maxwell playlist on that channel, that they'd had these experiences. It seems to me that the reason that the government brought that to the court's attention is because that was not disclosed in the jury questionnaire. We went over the jury questionnaire on this channel, and there were specific questions about SA. Then Juror 50 got a lawyer. The lawyers all lost their minds. They filed multiple motions with the courts, and the court has been litigating the redactions of those motions. What is a narrowly tailored redaction for the motion? What can be allowed in public? what should be redacted, and let's move forward. That all just got resolved. So we're going to work our way backwards. We're going to go to what the court ruled, and then we're going to go to the transcript of what Juror 50 disclosed. Then we will look at what Juror 50 said to the Daily Mail and others, and then I will tell you what I think. That's what we're doing tonight. I'm going to do a breakdown of the motions for new trial for the podcast. We're going to hit the highlights tonight because it's the most interesting shit. I will do a legal breakdown of all the other shit in a separate episode of the Emily Show. So let's go to the court's order from today and work backwards. Nope, that's not the court's order from today. Let's pull up the right court order. There it is. Maybe. Oh, my nose. I'm going to sneeze again. Okay. Let us get into this. Pam, and I'm going to get to the super chats when we get to questions. Pam, thank you. These are new. So I just this is my first set. So yes, I normally do them at night, but these are brand new. So, and then I'm sick. So it makes everything like, ugh. All right, court's order. Court's order from this was filed 2/24. This was posted to the court's website today, 2/25. Before the court is defendant's motion for new trial pursuant to Federal Rule of Criminal Procedure 33, which the government opposes. The defendant seeks a new trial on the basis that Juror 50, quote, falsely answered a material question during voir dire, and that had he answered truthfully, he would have been subject to a challenge for cause. We're going to go over the transcript. I don't disagree. The defendant contends that the current paper record sufficiently supports her motion and should be granted without a hearing. In the alternative, the defendant requests an evidentiary hearing to inquire into Juror 50's alleged nondisclosure. She also argues a broader hearing is required based on a news article that suggests a second juror was allegedly a victim of SA. The government urges this court to deny the defendant's motion on the current record, but it consents to a limited hearing on the issue of whether Juror 50 provided a materially false answer to question 48 of the questionnaire. The defendant's motion for new trial based on the current record is denied. Defendant's motion on the current record relies extensively on statements made by Juror 50 regarding what occurred during jury deliberations, and the court is prohibited from considering that under Evidence Rule 606. So the court's like, look, you've provided evidence that I can't consider. So the only way the court can consider that evidence is to hold a hearing. With regard to Juror 50's statements that do not pertain to jury deliberations, in order to resolve the motion at this stage, the court would have to accept those unsworn statements made to media outlets as true and reach factual determinations that are not available on the current record. This judge has been very, very diligent, and I appreciate it. Accordingly, a hearing is necessary to resolve the defendant's motion. The court concludes and the government concedes that the demanding standard for holding an evidentiary hearing is met as to Juror 50's answers to question 48 on the questionnaire. The court further concedes that Juror 50's response to question 25 is relevant to the inquiry. Following trial, Juror 50 made several direct, unambiguous statements, to multiple media outlets about his own experience that do not pertain to jury deliberations and that cast doubt on the accuracy of his responses to questions 25 and 48. Such statements are clear, strong, substantial, and incontrovertible evidence that a specific, non-speculative impropriety, agreed, namely a false statement during jury selection, has occurred. To be clear, the potential impropriety is not that someone with a history of sexual abuse may have served on the jury. Rather, it is the potential failure to respond truthfully to questions during the jury selection process that asked for the material information so that any potential bias could be explored. The judge has been very, very thorough here. Conversely, the demanding standard for ordering an evidentiary hearing is not met as to Juror 50's use of social media, nor the conduct of any other juror. The court therefore orders a hearing take place at which the court will question Juror 50 under oath. Juror 50 has got to be not thrilled. The defendant's request for a broader hearing and pre-hearing discovery is denied. Background: on December 29th, the jury returned a verdict in this case, finding the defendant guilty on 5 counts. A week after the jury announced its verdict on January 5th, the government informed the court that a juror had given at least 3 post-verdict interviews to press outlets about his jury service and request a hearing be held in the matter. The letter noted that the interviews were both in print and on video accurate. The juror described being a victim of SA and asserted that he flew through the juror questionnaire and did not recall being asked about whether he had been a victim of SA. We went through the juror questionnaire. It's clearly in there. The government indicated in a redacted footnote that it believed that the juror to be Juror 50 and review of his questionnaire showed that words are hard, that he had provided a negative response to a question that asked whether a prospective juror had been the victim of SA. So that footnote had been redacted and now is not. And they say that and this was what we speculated all along, the only reason that it came up was because the juror didn't answer that had been their experience. Because if the juror had answered, then the lawyers would have questioned that juror regarding bias, and the lawyers would have had the opportunity to explore that, which is necessary with the underlying claims in this, the underlying convictions in this case. With the underlying facts in this case, that is highly, highly relevant. And Icy J said, I guess I can never serve on a jury as a survivor. Don't know how I feel about that. That's not, please don't take that away from this. Survivors can absolutely serve on jurors and juries. Attorneys have the right to inquire when what someone has been through mirrors or is substantially related to the underlying charges. If you had been a victim of a carjacking and were asked if you could sit on a carjacking trial, they'd be like, can you do this? And some people might be like, not for this one. But if you had been a survivor of SA and were asked to sit on a carjacking case, your prior experience doesn't matter for that type of criminal case, or for a civil case where somebody slipped and fell in a department store or something. So it's only relevant because it's the type of thing the juror experienced to the type of thing that was going on in this trial. That's why it matters. So it's not that they had been a victim, it's that they didn't disclose it. And that the court makes that distinction really clear. And I think the court very mindfully looked into this, or very mindfully talked about this to make clear that the issue was the non-disclosure. It goes on to say, finally, the government requested the court offer court-appointed counsel to the juror. The juror got their own lawyer very quickly. The defendant filed a second letter that same day opposing the government's request because based on undisputed publicly available information, the court can and should order a new trial without any evidentiary hearing. The defense was like, this is so fucked, just order a new trial or order a new trial now, which is not going to happen either. The defendant filed a motion for new trial on January 19th, 2022. The government filed an opposition on February 2nd. The defendant filed a reply on February 9th. In addition to jurors 50's post-trial interviews, the defense motion relies on a New York Times article reporting that a second juror described in an interview having been essayed as a child as a basis for a broader hearing beyond the inquiry of Juror 50. Then they go into why they're denying the motion for new trial on the current record and the evidentiary hearing. For the reasons outlined below, the court determines that a hearing must be held. I agree. Regarding Juror 50's alleged non-disclosure during jury selection proceedings, the threshold for the evidentiary hearing is pretty high, but there needs to be clear, strong, substantial, incontrovertible evidence, which is the jury questionnaire, the transcript of the jury being questioned, and the articles they have to ask. Mere gossip and anonymous tips do not satisfy. Well, the juror is also on video. The defendant argues this is the wrong standard. I think it's the right standard, but also I think that it's been met. The court will conduct the evidentiary hearing on, which is redacted, probably to protect the juror in the proceedings, but I hope that we get to know some of it. The government acknowledges that Juror 50's answer to question number 48 satisfies the demanding standard for an evidentiary hearing. The court agrees. Question 48 asked jurors, have you, a friend or family member, ever been the victim of sexual harassment, SA, or assault? This includes actual or attempted or other unwanted sexual advance, like literally most of the women I know that have ever had a job, sadly. Unwanted sexual advance, including by a stranger, acquaintance, supervisor, teacher, family member. So really gets a very broad question about this. Docket number 46 at 24. In response to that question, Juror 50 checked the box for no. Not the box for either yes self or yes friend or family member. But in several public statements made to media outlets after the trial, including interviews in The Independent, and the Daily Mail, Juror 50 stated that he was SA'd as a minor. The statements are direct, unambiguous, and made by Juror 50 himself to multiple media outlets. Moreover, the statements themselves describe Juror 50's own experience. Footnote 4. The articles additionally state that Juror 50 shared this experience with the jury during deliberations. The court is prohibited by Rule 606 from considering that Juror 50 also told this information to the jury. That Juror 50 revealed that he also disclosed this information to the jury does not prohibit the court from considering Juror 50's independent statement made to a reporter about his own experience. Moreover, okay, we got to that. They constitute clear, strong, substantial, and incontrovertible evidence that a specific non-speculative impropriety has occurred. I think so too. And so an evidentiary hearing is warranted, quoting Baker 99 F 3rd at 130, which means that's the case name. Yay, Baker. They say that although the court does not decide whether the threshold to hold a hearing based on question 25 alone has been met, because the court will be holding a hearing on question 48, and question 48 and 25 are sufficiently related, the court will inquire about question 25. Let's talk about question number 25. Question 25 asks jurors, have you or any of your relatives or close friends ever been a victim of a crime? And that can be a crime that's charged, a crime that's not charged. That can be literally somebody having a purse snatched, a wallet grabbed, financial crimes. It's very broad. Like anyone you've ever known. Again, Juror 50 checked the box for no. But Juror 50's post-trial statements, if true, may describe criminal conduct of which he was the victim. So have you been the victim of a crime? The conduct states it. Sorry, my nose is getting feisty. It's like you've been streaming too long. They said, therefore, the juror's answer to question 25 is related to the answer for question 48. For a hearing, the defendant has not justified an inquiry into Juror 50's social media. This is like a how not to be a juror primer. This is also going to come up in like trainings for attorneys and law school. This case is going to have large implications. They say the parties devote significant portions of their briefs to the question of whether Juror 50 answered falsely the court's questions about social media usage during voir dire. To the extent that defendant seeks a hearing to probe Juror 50's answers to voir dire about their social media usage, their arguments are based on speculations, and they have failed to make the high showing required from the Baker case. At voir dire, when asked if he, quote, uses social media, Juror 50 stated, I do, but I actually just deleted them because I got out of a relationship and I didn't want to see anything regarding them, so I'm fully off it right now. The court then asked, what did you use? Facebook, Twitter, question. To which the juror replied, Facebook and Instagram, clarifying the accounts contained personal stuff like selfies. The screenshots proffered by defendant do not demonstrate that any of these answers implicate the test. Juror 50 did not deny having a Twitter account. Second, Juror 50's account had only one follower and followed only 39 people, which corroborates that his Twitter was at most relatively minimal. Third, the fact that Juror 50's Twitter account was open in April 2021 and that he used it again in January 2022 after the completion of the trial is consistent with the answer that he deleted social media accounts or just the social media applications shortly before voir dire. The same is true of Juror 50's Instagram, on which he posted January 2022 after the completion of the trial. And fourth, the screenshots proffered match Juror 50's description of his social media accounts containing only personal stuff like selfies. The defendant has not justified the inquiry into other jurors because that's too speculative. And then they talk about the news articles with the other jurors, but we're going to get to that example real quick. We're not going to get through the rest of this because here we go. Nature of the hearing. The court will examine the witness and the parties may submit questions. In concluding that an inquiry into Juror 50's conduct is warranted, the court is mindful that the object of the proceeding is to permit the truth to be discovered with the least possible harm to other interests. Accordingly, the court denies the defendant's request that counsel directly question the juror. A decision committed to this court's sound discretion. The court will conduct the questioning. I think that's appropriate. The court will conduct the questioning at the public hearing with input from counsel. The parties may submit questions consistent with this ruling, including what the court holds to be the opinion. What the court holds in this opinion are limitations imposed by Rule 606 and the appropriate scope of the hearing. Once again, the scope of the inquiry is. It's interesting that that's redacted, but it's going to be about Juror 50's answers. Per the court's prior order, the parties must submit proposed questions under temporary seal to ensure the integrity of the inquiry because they don't want the juror to know what the questions are before the juror shows up. Proposed question must be submitted by email before March 1st, so the hearings after that. The proposed questions will be unsealed following the hearing, so we'll know after the hearing what the juror was asked. The defendant's subpoena requests are denied, so you're not subpoenaing anyone else or any other information. The court will release Juror 50's questionnaire. That's what we're going to look at next. The court previously reserved ruling on Juror 50's request that the court release his jury questionnaire to counsel, but the document otherwise remained under seal to protect their supposed privacy interest. The defendant opposes both the unsealing and releasing of the questionnaire to counsel, arguing that advanced disclosure will undoubtedly color Juror number 50's testimony and allow him to place himself in the best possible posture. Well, the shit's out of the horse now. We already know he didn't answer it. Or we already know what the answer was, that the answer was no. They say the government argues that there's no legitimate interest in limiting Juror 50's access and opposes maintaining the questionnaire under seal. The court will provide Juror 50 a copy of the questionnaire. Unlike the parties' proposed questions, Juror 50's access to the completed questionnaire, the answers which he wrote, will not undermine the integrity of the inquiry. The defendant's concern that advanced disclosure may somehow taint Juror 50's testimony is unfounded. Moreover, the court concludes that the presumption of access dictates that the questionnaire must be docketed. Juror 50 and the defense request that the questionnaire remain sealed. It's governed by a 3-part test, and it's already been unsealed. Finally, any privacy interest may have had, you can narrowly tailor some redactions. The defendant is accordingly ordered to docket Exhibit 1 in her motion for a new trial, the completed questionnaire. For the reasons stated above, the court will hold a hearing regarding, there's the date, regarding Juror 50's answers to questions 25 and 48. The public proceeding will take place March 8th, 2022 at 10 a.m. I'm sure there will be lots of media there. The courtroom 906 in the Southern District of New York. So ordered. Let's go look at the questionnaire. And then we will get to questions. Not questionnaires, questions. We'll get to questions. Let's see, where is it? All right. We are not going to go through the entire motion for new trial. As I said, I'm going to do a podcast episode on that. We're going to, and the court really thoroughly laid out the arguments. We are just going to get to the attachments. The defense's motion is over 100 pages long. So we're just going to get to what's attached for our purposes because the court, we know what the resolution is because the court already ordered the hearing. But I think that it is likely that a new trial will be granted based on this. So let's go to this questionnaire. I'm just trying to scroll up to the right part. Excuse me for the snuffling. Um, so like we've got the I juror 50 declare under penalty of perjury. Um, let's see. 47 witnesses in the case may testify claiming SA or S assault. Would you have any difficulty assessing the credibility of a witness claiming that? No. Have you, a friend or family member, ever been the victim of harassment, abuse, assault? This includes actual or attempted or other unwanted advance, including by a stranger, acquaintance, supervisor, teacher, family member. Yes, self. Yes, friend or family member. No. If yes, please explain. And that's where they would explain. If your answer to 48 was yes, do you believe this would affect your ability to serve fair and impartially? And then you can answer. Like there's room to explain. Hey, Fred. 49. Have you or a friend or family member ever been accused of those things? And then let's go look at number 25. Fred, oh, you're so warm. Did you just wake up? Did you just wake up? Oh, you did just wake up. Do you want to say hi to the law nerds? No? Okay. All right. He's all like half asleep still, but very, very toasty roasty. You're so warm. All right, let's go look at question number 25, because again, the court already said it. Let's see. Oh, Suzy Q, thank you. I did Friday Night Live because I felt like we all needed a distraction from everything else going on in the world. And we talked about this so much on Tuesday, and so much happened since Tuesday. So thank you very much for your support. I appreciate it. So Juror 50 read on the website that she was Jeffrey Epstein's girlfriend on CNN. So that's kind of knowledge of that. That's not question 25. We're trying to get to question number 25. We're almost there. We're so close. So close. All right. Have you or any friends or relatives ever been the victim of a crime? No, and then not explaining. I can understand why some people might be like, oh, I didn't really consider it a crime. Nothing happened. I thought you meant something had to happen. Like there had to be a police report. I can understand people being confused about, like, well, it never went forward in a criminal way. So I'm not sure. But are you trying to knock me in the face with my own microphone, Fred? But with number 48, there's just no way around that. And then they attach the transcript. So let's go to the transcript real quick and see if it's just that part, because they attach the voir dire of this juror. And so this juror is going to have this too. Fred's just going to be feisty. Let's see. Good afternoon, juror number 50. So they are interviewing these jurors independently. So they talk about the presumed innocent. They talked about the instructions. They talked about the schedule. It's going to last 6 weeks. Let's see. There's the instructions. Can you put aside anything you've read about the case? Absolutely. Can you follow the instructions? Yes. In your questionnaire, you indicated that before the questionnaire, you'd heard of Mr. Epstein. What you described, you said CNN. Other than that, other than what you have described, do you recall anything you've heard about Mr. Epstein? Not really. I don't really have cable, so it's very rare that I see anything. Based on what you did hear or read, can you put it aside? Yes. Any doubt about that? No doubt. Let me ask you, do you have any reason you think you might have any bias either for or against law enforcement? No. And these are just your general voir dire questions. Fred, you are so weird. You were just drooling on me. How old are you? 35. Where do you live? What did you study? Finance. What have you worked in? Do you typically read any newspapers or magazines, either in print or online? No, I do not. Do you frequently visit any particular websites? No. Ever commented or posted on any websites? No. Do you use social media? No. Like, what? You don't go to any websites ever? Like not Amazon? Not, I guess. Do you frequent or visit any particular websites? Yes. I do. But maybe it just works a lot. This is the actually deleted them, used Facebook, Twitter, Facebook, Instagram. What kind of stuff would you post? Personal stuff like selfies. How long ago did you delete your accounts? It was actually last week. Uh-oh. Uh-oh. Schnoz pause. Sorry. Do you watch television? I have Netflix. Comedies. Do you listen to the radio? No. I listen to music. What about podcasts? No. Hobbies? Do you do anything for fun? Travel, hanging out with friends? Have you ever followed a criminal case either on the news or podcast? No, I haven't. This is just all the jury questionnaire, so we're going to try to get and that's it. They didn't ask them about number 48 because he didn't answer yes to 48. So it didn't even come up. That's a very quick voir dire because it wasn't answered. And because the attorneys didn't get to inquire, I really think they're going to get a new trial. I really do. I don't see how you get around it. I've read the articles, I've watched the interviews. I hope that this juror didn't want to get on this case to watch this person get prosecuted. Like, wanted to just be like, no, 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 I don't do anything. I do nothing to try to get on you get people who want to be on high profile cases, and it's something you have to look out for. I want to be on this jury. I think this person did this thing, and I want to have my say. I hope that's not the case. I hope this is just a mistake of I wasn't paying attention. However, this mistake could undo this entire trial at great personal expense to the victims that testified, that might have to testify again. And that is, yes, there's expense and time and court time and all of that, which is, a thing, but not the most relevant thing. The most relevant thing is that all of the girls involved in this trafficking have to come back and do it again and have to come back and testify again. And testifying at a second trial is so much harder because there's so many more transcripts. So everything they said in the first trial, it's going to be like, well, the first time you said it this way, did you mean it this way or that way? It becomes a much more difficult type of testimony. It's very interesting to me that he was on this jury and then went and talked immediately to the Independent and the Daily Mail. How did they even find him? How did he find them? Fred is just like, I went to be snuggled like a baby. We're just here. This is where we are tonight. This is not going to go well. And by well, I mean it's probably going to end up in a new trial being granted. The reason the judge did not grant the new trial on the papers is because the judge is like, I don't know if what was said to the media is true. So this person could come in and be like, no, I just lied to the Daily Mail. It's going to be were you lying then or were you not lying now? What happened? Like, what happened? And the media statements were, I went through the questionnaire really fast. I don't remember being asked. And he said to the media, if I had been asked, I would have answered honestly. But you didn't answer it. And that puts the defense at a huge detriment, not being able to inquire. So let's get to questions. Fred, should we get to questions? I need a hand. I need just one hand. Okay. Can you floofball that way? Thank you. We need to swoop and get to questions. I'm going to get to as many super chats as I can, but let's get to questions. What is it? 2:22? Me. It's going to be short. Also me. 2 hours and 22 minutes later. We're just getting to questions. But we all needed to have a chat tonight, didn't we? Like, we all needed to have a chat. We all needed a chat. I needed to chat. We needed to talk about something else. We all needed a chat. And then I get to just go to bed and we're going to sleep. Coffee buzz. Yeah, it is super sus. My 10-year-old says sus all the time. It is super sus. It's sad. Do you hear Fred just knocking shit off my desk for attention? Fred. At least it wasn't the nail polish that's on my desk. Yikes. I don't think he can plead the fifth because I don't think there is I don't think they're going after him for perjury, even though the questionnaire was signed under penalty of perjury, but he might want to try because it is signed under penalty of perjury. I don't know if the government's going to have to offer him, be like, look, we're not going to prosecute you for perjury so that you can testify, but it is a real possibility. And that's a possibility. It's like, was this your answer? Is this what you told the media? It's going to be a mess. And it makes me look, the people who are going to be most harmed by this are the victims who have already had to testify once and are very, very likely going to have to testify again. That's who is hurt by Juror 50 not disclosing this. But the defendant has a right to a fair trial. And the defendant did not get that if their attorney wasn't allowed to ask this person. If this person had said on their questionnaire, I was a victim of child SA, they never would have even made it into the pile to come into court. They would have been challenged for cause, and the court would have been like, yeah. So there's no undoing that. You can't put the shit back in the horse on that. The only way to undo it is a new trial. And it's just, it's frustrating. Like, it's really, really frustrating. But it's also the defendant's rights, and the defendant's rights have to be protected. Those are their constitutional rights. And it's just, it's just. Hazel, this is a great question. It could be that he misunderstood the questions. And if he misunderstood the questions, that's still not going to save, that's not going to save it. It's just, hey, this wasn't done maliciously, but it still happened. And if it still happened, a new trial is the appropriate remedy. So even if it wasn't done maliciously, it's still a problem. So it's just going to be a mess. All right, let me try to get to some of the super chats and some of your questions. Please put question in where it says questions. It'll make it much easier for me, especially because my brain is working super slow and but it's just odd. It's odd. It's sad. It makes me mad. Lillian, thank you for the super chat. Or the super sticker, it must have just come in. I didn't get to pull it up. Thank you so much. We appreciate it. I'm sure YouTube will be angry with this video as it's been angry. Every time I say the GMAX, YouTube's like, we can't talk about GMAX. I'm like, look, man, we have to have conversations about what goes on with juries and jury trials and people's rights and constitutional rights and how this all works. This is how this works. What if he said he was lying in the interview? Will they have to investigate his claim or just grant a new trial? I don't know what'll happen if he said he was lying in all the interviews. Maybe ask for a retraction, but it's a pretty detailed statement on video, but I don't know what they'll do. And I don't want to speculate on that too much because the hearing hasn't happened and we don't know what Juror 50 is watching in the media. Juror 50 is going to be under oath, and Juror 50's best bet is to just be honest. And if this was just an honest mistake, it sucks, but it needs to be fixed. JC said, imagine being the person that provided context to the jury to get GM convicted, then also being the person to undo it because you wanted to brag. I mean, yep. Susie Q, thank you again for the super chat. Hazel Angus, my BF, said that Juror 50 could claim he didn't lie, but was triggered by memories resurfaced. Do you think this would fly? That wasn't in any of their statements, and I don't know what they will say. So I'm going to try not to speculate on that based on what I previously said. So I don't know. Pam, thank you for the Invisalign recommendation. Sister Babylon said, stratagem, a plan or scheme, especially one used to outwit an opponent or achieve an end. Well, thank you so much. I have learned something new. I love learning something new. Latasha, thank you for the super chat. Sister Babylon said, was he using Korean Botox like Dr. Jen or something? Oh, with regard to Dr. Laguna, the video is in depth. Lots of allegations of grabbing and not having nurses in the room and inappropriate comments and letting unlicensed practitioners do surgical procedures, lots and lots of allegations. Not like Dr. Jen. I personally think worse. Sister Babylon said, can we get a stream with Natalie Lawyerchick discussing what she'd do as a defense attorney in the GMAX case? I mean, I can ask her. She and I talked about the GMAX case a while back, so I can definitely ask her. Does GMAX stay in jail? Yes. Even if they grant a new trial, she stays in jail until the end of the new trial. 9 to 10 trucker said, found you through Natalie Lawyerchick. Oh, that was from the last video. Well, thank you. Let's see. Mandy said, oh my goodness, Emily, are you in the prosecutor protection program? I am not in a PPP. I just moved states. It all works. Oh, my nose. Hold on. We need a schnoz pause. Are we going to sneeze? Oh, I think we're good. I think we're good. There's a super chat asking, can anyone just rent an excavator like that? How the heck did David even get access to such a dangerous piece of machinery? I have no idea. It wasn't addressed in any of the videos that I saw about it. I just wonder if it was money. Like, hey, we'll give you this much money to let us use it. Like, I have no idea how he had access to that massive piece of machinery. But again, if you want context with the Dobrik Jeff Whitick thing, it's tough to watch, but it's all on Jeff Whitick's channel, and the graphic stuff he put behind a paywall on Patreon, so it's not the horrible stuff, but you still see him hit the excavator, and it's chilling. It's just chilling. Let's see. I was going to get to Jessica's question. Jessica said, can other members of the jury be questioned during the hearing, as in if he did or did not say anything about SA, no details, just yes or no? They can't. They are only questioning Juror 50, and they are not questioning about what happened in deliberations under Rule 606. They are only questioning about what was or was not said to the media, and what was or was not said on the questionnaire. So that's a great question. Thank you so much, iCats, for the kind statement. Question on the form in this Kimmy A suit. If you check both, I do not consent to this order, but I would consent to this. Do you write in whatever it would be that you would agree to? Generally, they do it as attachments, and generally the lawyers have those conversations behind the scenes first. These lawyers. I got yeeted out of my own stream. Apologies. Apologies. Question, could Kanye be gearing up to go up against Lou Taylor, since isn't Lou connected to the Kardashians? I have no idea. I have no idea what his what he's trying to protect or what the goal is. I just don't know. But no, I don't know why Kanye would have any legal thing with Lou Taylor. But yes, apparently she still is connected to the Kardashians. So Cynthia said, okay, but Emily, over half of women have been SA'd or harassed, so most women couldn't serve on a jury about these topics. That's a problem. It's the lived experience of women and many men. Cynthia, I agree with you, and they would be questioned about it. And that is the part that's the problem. It's not that they can't serve, because it says under it, would that affect your input? And the attorneys then with the judge argue for cause, and if somebody says they can be fair, they wouldn't necessarily be kicked for cause, but the rights of the defendant are the thing that take priority here, and that is the number one right that is protected. So if somebody said that they could not be impartial based on their experience, they would be yeeted for cause. If somebody said I can be, but the lawyers disagreed based on what they answered and what the situation was, then the court has to make that decision, and that's something that can be appealable. So I completely understand. I did not do cases in this realm. We kept victims of crime on in criminal trials. I did, depending on what the crime charged was, what their experience was, how long ago it was, how much it impacted their life, all these things. So this is all part of picking a jury that can be fair to the defendant, because that is what matters most. So I hear you. I feel the frustration, but the lawyers have the right to inquire, and the jurors have to give them a truthful answer so they can inquire. Thank you for the super sticker. JC says anyone can rent an excavator and they don't require any licensure or certification. That seems like a problem. And Katie says in Germany, you can easily rent smaller excavators. People need them privately. Really big ones, I think, are generally used by companies, though. I mean, it's kind of crazy, right? Question: can Kim put criminal charges towards Kanye with personal things being spread and the possible threat to her safety? I didn't see anything that to me raised flags in California of criminal threats, which in California is a 422. I didn't see anything that raised to that level for me. Um, it's not an easy thing to do when it comes to threats. Sharing personal texts and stuff isn't, in this context, isn't criminal. Like, we're not tipping into like the stalking realm. So with that, if Kim thinks it crosses the line, then she should absolutely do something. But also it has to, with like criminal threats and threats of harm, there has to be kind of an immediacy and an ability to carry it out. And she has security in these things that might weigh in favor of, could he do this? Could he not? So the harassment might be civil, the intentional infliction of emotional distress. I don't think she wants to start any more shit with Kanye. I think she wants to be divorced and be able to move on. But if she needed to go the route of a restraining order, that might be able to happen within the court. Um, so Question: do you think it's possible that the juror was planted to screw with the GMAX trial? I hate to be a conspiracy theorist, um, but I elf it. I don't know. I don't know. It's just a really, really odd thing. And it's really odd that it came up. It's really odd how many interviews they did. It's an odd situation. So I want to know more. I want to know more. It's an odd situation. Question: will you be covering Megan Thee Stallion and Tory Lanez? I will. I touched on it very, very briefly when he was charged. There hasn't been a ton of information about the circumstances. So more information will come out as this goes. Has it gone to preliminary hearing? Is it getting ready for preliminary hearing? I will touch back in on it. I need to look and see who the DA on the case is. I'm curious about that. So let's see. Um, Question: do you know if GMAX has been sued civilly by any of the victims? GMAX was covered by the victim agreement that Epstein did, but she was sued by Virginia um, Giuffre for defamation and other things. GMAX is still facing 2 counts of perjury that come from that case for things that she said in deposition. So there are still pending counts as well. Question: are you coming to Las Vegas in April for CrimeCon? I had not planned on it. I did not know CrimeCon was happening, but I will look. I have to look at what else I have in April, because if I go to the Shah trial, that will go into April. And then I have the live event in Nashville in April as well. Thank you, Colleen, for the super sticker. What else? I'm going to go for a few more and then we will then I'm going to say good night. So, he Amara said he physically threatened Pete Davidson on social media, which if Pete wanted to go after him for, he could make a police report and go from there and try to get a restraining order. I think Pete might have an easier time doing that than Kim at this point. Would Juror 50 lose monetary compensation for being a juror? I don't know. I'd have to look. I don't know off the top of my head. I hope you feel better soon. Thank you. I do too. Yesterday, if you guys watch me on Instagram, and if you don't, at the Emily D. Baker, I was fine yesterday. Like, I walked on the Purple Beast, which I'm loving. I did a little bit of yoga. I hung out with the kids, got Travis packed to go camp. Hung out with Dr. B, like had like a chill evening, took a bath, read a book, like good evening. And my nose was a little drippy. And then I was like, what happened? Like, what happened? I woke up this morning just feeling terrible. So we need to do COPO. You're right. We need to do COPO. We do. What's the Purple Beast? Well, you have to go to Instagram. It's in my stories. So I was like yesterday, I sounded fine. I thought it was fine. Okay. Let us go to and this actually might be true. So when stress levels change in the body, like yesterday was the first day, and it kind of feels like that, like when you come home from school for like winter break or come home from college for winter break and then you get sick because you finally decompressed. I feel like yesterday I finally decompressed enough and then my body was like, good, we're sick now. Because I definitely have a cold. Like it is not, this is not allergies. This is sinusy, icky, plus, plus. So let's roll COPO. We talked about this on Tuesday. So those of you that watched on Tuesday know what is coming. We're going to have to formulate a question. And I'm going to have to put this up in a poll. Hold on. Let me make sure I can still do that. Okay, great. Let us go to COPO. Here's the hard thing with this COPO. Because we talked about this Tuesday and there are so many options and we're going to have to narrow them down because social media lets us vote on 4 and we've seen that your girl has a hard time with a tier list. We can't do a tier list. So the question is, what Britney Spears song, lyric, or title should she name her book that we know she has a book deal for? What should it be? Because we had all kinds of ideas on Tuesday. Toxic, overprotected, we had others. There were so many others. Scream and shout. Stacy, great idea. Scream and shout. I don't know if Lucky works, Piper. I feel like Lucky would be like a backhanded compliment. Circus. It's Britney bitch was one of mine. Dr. Riley, I think it's 2 on the nose. Stronger than yesterday was also a thing. So stronger than yesterday I like a lot. And I think it has to go on the list. I think toxic has to go on the list. So let's see. I'm going to write them down and put them on the list and then I will vote on them on social media. Toxic, it's Britney bitch. I kind of love the complication of the two. All Eyes on Me is great. All Eyes on Me is fantastic. I like All Eyes on Me. I like here. I like Stronger Than Yesterday a lot. What else? So I'm gonna keep looking. Me Against the Music. Piece of Me is also fantastic. Center of the Ring, love it. Like it's just circus, not a girl. With the subtitle. So it's If You Seek Amy is pretty funny too. Never Look Back, they say. You Want a Piece of Me. Marco, I like that too. Circus is going on there. It's got to. That was a very long schnoz break. I schnoz pause. This is hilarious. You better work. I mean, I think that's directed at James. Dr. Riley, Born to Make You Happy is also 2 on the nose. It just makes me sad. We need it to be I don't know, sassy. I want sassy, I think. Do you want a piece of me? I like What a Piece of Me, and I like It's Britney bitch. Overprotected is good too. Overprotected feels like the easy one. So I wonder if we do like a runoff because I think we can do more options on YouTube and then run them down once we get to 4. Run them down on Twitter because I think we can only do 4 on Twitter. Maybe we can only do 4 here. I will find where we can do 4 or 5. and then we'll figure it out. Because I really, I think I must confess, maybe has to, um, maybe. Um, you took a piece of me. It's totally fair. Want a piece of me? It's toxic. You drive me crazy. I just can't. I mean, she definitely said that, didn't she? My prerogative, fair, but a cover. Um, the biopic title proposal. Her daddy loves her. I mean, right? Yes, it is only 4 on Twitter. That's the problem. Um, all eyes on me, stronger than yesterday. You want a piece of me? It's Britney bitch overprotective. How many is that? 1, 2, 3, 4. That's 5. But I can put those on um I can put those on YouTube and then run down the top 4 on Twitter, which is what I think I'll do. 1, 2. Yeah, I think that's what I'll do. I mean, lonely also only lonely also is like so on the nose it hurts me. Um Miss American Dream since I was 17. That is totally fair, Dr. Riley. That one I like. I feel like it could be like toxic. I miss American Dream since I was 17. Hit me baby no more time. Fair. You guys are fantastic. Criminal might be perfect. Criminal might be perfect. Blackout might be too on the nose. But I'm going to put 5 of these up. We'll vote on them. I love all of the input. So, Lucky also hurts. Dear Diary is great. That's a great option. So oh, that is you guys are so sweet. Thank you for the chicken soup and Tylenol. That's what we're doing for now. Thanks for still doing FNL Get Well. I did it because I really did want to chat with y'all about sit down, Miss Thoren. I mean, it's very on the nose. We still need to do a reading of the last court hearing. That's gonna have to happen too. So I'm there for y'all as well. So thank you. Thank you. From the bottom of my broken heart is really, really strong, Sandra. Oh, do you guys? All right. Do we have what 6? Maybe we'll put up 2 polls and then take the top 2 from each on YouTube. Let's see. 1, 2, 3, 4, 5, 6, 7. We could do 2 polls of 4 each and then take the top 2 from each pool and do a mini runoff here on YouTube. And that's what we do. I think I'll do that. I like Sandra's too. I like it too. So that's what we'll do. We'll do 2 and then we'll take the top 2 from each. And then we'll put those on Twitter on Monday and then we will rule on Tuesday. So we heard Slave for You. It just feels so on the nose. It just feels so on the nose. I like Unbroken too. But we should definitely use what Jamie was going to use, which was what? I Must Confess? Is it I Must Confess? Is that what was the one that Jamie wanted to use? Was it I Must Confess? I think so. Let Me Be. I mean, that's totally fair. So please share on AG when you post the polls. I don't see community tab unless I'm on a PC, which is never. That's totally fair. I will post it and I will, because I can run it down on both Insta and here. I Must Confess. I think that has to go on the list too. All right. We're gonna do 2. We're gonna do like a mini rundown. And I will put them on Instagram. I will put them on the community tab right after I get off and put my put the timestamps in. And then I will put, once we get the top 4, those will go on Twitter and on the community tab. So I think we narrowed it down to 8 that are very good. And I'm sure there will be others. And I appreciate all of you. I have got to go. I am dead. I appreciate you. I will see you back on Tuesday. I will have a new video up. Hopefully tomorrow, but maybe on Sunday. Just depends on me. And the new episode of the podcast will be out Wednesday, but I will see you on Tuesday. I'm going to go rest. I will probably not be on social much this weekend. I am going to sleep a lot. So thank you for being here. Thank you for being a law nerd. I appreciate you. Hopefully the world doesn't just collapse this weekend and we're all just gonna take a deep breath and we're all just gonna take a deep breath. And I appreciate you. Thank you for being a law nerd. Thank you for being here. I will see you in the next one. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.